Let's bring a semi-workshop to order. We're going to start off with public comment. Again, you guys most of you have been through this. No reason to make public comment when we're going to go through all the workshop steps. You're going to have plenty of time to make comments about the workshop as we go. Sarah, you want to go ahead and we're going to limit public comments to 3 minutes. Sarah, you want to go ahead and read your...
Sure. To provide public comment via telephone, call 669-444-9171. Enter webinar ID 876-5971-1892, followed by passcode 398178.
Thanks, Sarah. And you're giving public comment, please feel free to come up, have a seat in one of these chairs. Let's start with public comment down here in Las Vegas. Surprise, surprise, everybody's saving stuff for later.
Ready for this.
Any public comment online, sir?
Yes. Will Adler, go ahead.
Thank you. There we go. Thank you. I just wanted to thank the CCB for holding this workshop. My comments are written for the most part because I might not be able to actually make the particular part of the hearing that I'm intended to because I have another meeting at the same time. Please reference my written comments. I'll try and join us again later. But thank you again for holding this hearing. I think it's a step in the right direction.
All right, thanks. Anyone else there?
If you wish to provide public comment, click the raise hand icon at the bottom of your screen if joining by Zoom. If joining by phone, dial *9 to raise your hand. Glenn Miller, go ahead. Mute to begin. Glenn Miller, go ahead.
Yeah, no, the question is there an opportunity to talk about specific issues as you go through the agenda, or all public comment is going to be now? What's the difference? I'm sorry.
I guess I can respond to that. As stated in the beginning, you're going to be able to give comments on the regs as we go through the agenda.
Great, thank you. Thank you. That's fine with me. Oh, wait then.
There is no additional comment.
I'm going to start off with the event regs. First, though, I'd like to introduce Jimmy. Jimmy wants to introduce himself to everybody and make a statement.
Yes, just want to say thank you, everybody, for taking the time to come down here today. Extremely important that we work with everyone on these workshops, especially, again, this is a great opportunity. During the meetings, we're not allowed to respond to public comment. But today it's a great opportunity for voices to be heard, public comment that was submitted. And kind of in the vein of that, mentioned it at the last board meeting. Again, if you haven't seen that or had the opportunity to meet me, I'm Jimmy Hum, the incoming executive director. So I'll just actually kind of read this, but as part of a larger effort to inform future policy for the Nevada cannabis industry, the CCB has hired TPMA, an independent third-party evaluator, to conduct a comprehensive study and emerging sector analysis. We're encouraging participation in this survey by both consumers and industry folks, as your participation will help give policymakers insight into how the industry can be improved. The information collected throughout this survey will remain strictly confidential. No individual responses will be shared either publicly or privately with the state of Nevada Cannabis Compliance Board or anyone else outside of that independent research team. Top-level survey findings will be provided for us and will be included in the publicly available report once it's completed. So we encourage you to fill all that out. There are links and QR codes on our website. We've had a terrific engagement thus far, but it can always be better. And just based on how many folks are here today, to have their voices heard. We feel like that's another avenue. So we'd really encourage participation in that. Won't take more than 5 or 10 minutes. So if you do have time, please take it. Again, just wanted to say overall, thank you. Just wanted to pop in. Appreciate everyone on the phone. Please share all of anything and everything with my incredible team. I'm going to turn it back over to them as I pop out, but everything shared today will be brought to me and we will discuss internally. So thank you so much for your time today. And please reach out to myself or the team if you need anything. So thanks. Deputy Director Miles will take over. Appreciate it. Thanks everybody.
Again, I want to start off with on the temporary event, temporary cannabis event regs. We had a big workshop on this before. I want to point out, I think one of the biggest comments we received was that everybody wanted smaller events. Again, we limited to 10,000 on this. For those of you that do know, smaller events came up in the last 2 ledge sessions and were not approved so far by the ledge. We mostly feel here at the CCB that if we're going to have smaller events, it's going to have to go through statutory changes to have that. This is just going to be large scale events, and these should only be a few probably in the state. I want to apologize to Scott Rutledge. He had a large comment on here that he gave us 2 weeks ago, and we discussed in depth. And I know he's talked to a lot of people about it, so I want to apologize to him about that. And I'm going to allow him to go first if he wants to. Oh, and Chris, do you want to come up here? Just any questions? Everybody, this is Chris Anderson. This is primarily his bill, or not his bill, but his regulatory change that he submitted to the CCB 2 years ago.
18 months-ish, okay.
Scott Rutledge with our Gentleman Partners for the record. Deputy Director Miles, thank you for that. I realize that what I sent you and Director Hom did not include the CCB, the regulations so maybe that's why it didn't make it to the print pack. But as has been discussed, really it was just one change to subsection H under 5.041, which talks about the proposed physical address and the distance setbacks. And as we've discussed, permitted events are not contemplated in statute. There's no definition for cannabis event in statute. And so understanding we want these setbacks in place because we have, certain, we've done that with establishment licenses, but recognizing that being in this regulation is also not a statutory requirement. In that spirit, having had conversations with a number of stakeholders and members of the county commission as well, who would then have to look at an ordinance, came up with a very narrowly focused language that would basically take subsection 2 and 3 and delete the current wording, because it doesn't make sense that you would apply for a permanent event and then move it, especially something of this size, and just replace it with an applicant may request a waiver of section sub H1 for the attestation and distance requirements if the event is a cannabis event trade show. And then, sorry, that was the prior version. There was one extra section to that language. And I thought I had it on my phone here. So I apologize. 1 second.
If you could please resend it to the reg.
I did include them on that email to you. So it is in the body of that. But basically, so it would say an applicant may request a waiver of the attestation and distance requirements in section H1 if the proposed is a cannabis business trade show and the proposed venue is primarily controlled by public officials. So that was the request I had suggested. And I did work with Mr. Sala on that language as a suggested language. So I don't know if there's any questions but again, that's the conversation. One other thing I would note is if the state says, yes, we'll include that, we still have to go through the county process and an ordinance, right? Anything's gonna have to be permitted at a local level. And if it is a public building controlled by elected officials, obviously you're gonna have to get those approvals as well. So this is a multi-step process, but this would be the first step. So
Appreciate it.
thank you very much.
Usually I'd go through these reg 1, but I think majority of these people here have been through this. There's only 2 one real major change to these regs that were made since the last workshop, and that was changing a 25,000 person event to 10,000. So it's going to be 10,000 or above that these regs will apply. 10,000 below, we're not going to give permits for, or wouldn't give permits for. So again, feel free to make comment on any section of the event regs right now.
Quick clarification question. So if it's less than 10,000, then a permit is not required? Is that what I?
Less than 10,000, no event will be allowed.
Oh, okay.
Well, no permit will be issued for that event. Let's make it that way.
Good afternoon, Amanda Connor with the law firm of Connor and Connor for the record. First, I think it's important to note that the materials were not available until yesterday afternoon. It makes it very hard to comment on regulations. I do realize that there were
This from the person that makes the last minute comments all the time, but I agree. We just got this in, we made a couple changes last minute.
Yeah.
That's why I got brought up at the very end. Sorry about that.
And that is I went back and looked what was discussed at the earlier workshop, but without knowing what was going to be changed, right? It does make it very hard to prepare comments, especially when we're preparing comments about all other sections of the regulation for this workshop as well. Regardless of that, it was only up yesterday afternoon. I do think it's important to note a couple things. One, a lot of these regulations, if you look at them, are mirroring or taking from the consumption lounge regs. We do not have a consumption lounge yet licensed or operational in Nevada. And I think staff knows we've been working on it. There are things that need to be clarified, tweaked, worked through with those regulations. Consumer safety, employee safety, product security, things like that that are coming up as we're going through the lounge process, thus making this a bit premature. Secondly, I think Deputy Director Miles referred to it, but the legislature has been permitted to address special events permits. Twice there have been bills, and twice the legislature has declined to permit special events. And I don't think they said we're not permitting small, less than 10,000. It was they didn't adopt special event permits. And I would ask, there's lots of lawyers out there, but I'm not sure there's the legal authority or statutory authority for the CCB to create a new license category when the legislature specifically decided not to adopt special event permits. We are coming up on another legislative session. They will have the opportunity to voice it. Hopefully by then we'll have some lounges open and have some established precedent on how these work out. So I kindly submit that this is premature.
Anyone else? On event regs? I know most of you are here for the second part of this, but.
Good afternoon, Eva Black with Solid Consulting here on behalf of Hardy Premium Dispensary. We're excited to support this regulation and look forward to its successful implementation. Thanks for your time.
Thanks. Chris, do you want to quick give the authority out of the statutes that do you remember where that's at? Or you want to send it to her later?
Yeah, I'll grab it from my phone.
Yeah. By the way, because sorry, as was mentioned, as she said, these are CCB regs. Again, this is a petition to adopt regs. CCB did not create any of these regs for the event.
Got it. Bri Padilla, for the record, I work as the executive director of the Chamber of Cannabis. I've also been a community leader and organizer for many years. And I just wanted to highlight that a lot of the concerns and the stakeholders, their concern, I appreciate the apology at the beginning, but they weren't really answered through this. I do think it's an odd positioning to take to start out by saying, hey, the legislature said no to special events, but we're going to push these kinds of special events through. And it would be great to continue working collaboratively to see places where we can have more sizes looked at. Thank you.
Thanks. Haven't seen you in a while.
Lake Martin on behalf of the Nevada Cannabis Association. We wanted to thank Deputy Director Miles and as well as Chris Anderson, the proponent staff, Director Hum, for working on these regs and getting them to a point where the NCA wanted to voice our support for temporary cannabis events. We appreciate the reduction in the attendance to 10,000, potentially opening up more opportunities for events while still keeping them at a size that is, large. And we hope that in the future, when these are shown to be safe and successful, that maybe we do look at lowering the event attendance to less than 10,000. But I think this is a good start and a good step in the right direction. I think that there was one question remaining, and one of the comments in writing raised it, which is jurisdictionally, like if you are in one local jurisdiction, where can you do an event? And I know that we had discussed that at the workshop as well, but I wasn't sure if that was incorporated.
It hasn't been yet. Again, it hasn't been decided. We're going to discuss it. My personal opinion is when you set up that fence around there, that's an extension of your license. So it's going to have to be within the jurisdiction
In which
you're licensed.
located.
Yeah.
And that's all. We just wanted to say thank you and let you know our support.
Great. Thanks.
Hi, good afternoon. My name is Nick Jackson. I represent RNBW, which is a cannabis brand based in California and Nevada. Just wanted to thank you guys for having me. I'm very much in favor of what you guys are proposing. I think it would be extremely positive for Las Vegas and Nevada and the cannabis industry in general. I think it would give an opportunity for all types of license holders to thrive, from cultivation to retail to brands. I think experientially, it would be a great addition to what the state is doing and how progressive it's been in cannabis in general. And I think that by encouraging a certain cap of 10K people, it will mean that only professional operators will be able to participate, who have presumably a lot of experience dealing with a lot of the concerns we may have. So in general, we're very much in favor of this and would very much like to see it happen. I think it would be fantastic.
Good. Appreciate it.
Thanks.
Anybody else down in Vegas would like to talk about the event regs?
My name is Austin Barbell. I currently represent Cookies on Flamingo. And first and foremost, we are very much in favor of moving forward with this as well. This would be a really great opportunity to not only allow dispensaries, but also employees to interact not only with each other, but also with our customers that we have, continue to create that camaraderie. And I think that it'll really create a nice experimental, but also influential experience and further diversify our industry, as well as allow a little more creativity. Really just overall a really great experience for all four of our walls.
Great. Thanks. Appreciate it. Any other comments on the temporary event permit? Is there any, oh, never mind.
Good afternoon. My name is Virginia Valentine, President of the Nevada River Association, and I represent the group that you have to have a 1,500-foot distance separation from. I don't know the name of the first lady to speak, but I'm going to agree with her. We haven't had a lot of time to do the legal research on this. We have some questions about whether or not this is permissible and we could create a new category of licensing. I just want to get on the record. We're taking a look at it. We fought very hard to get those waivers in the 2019 legislation, and I have a feeling that my members want to fight very hard to maintain them. So thank you very much.
I mean, keeping the 1,500 feet or the grandfather clause based on the 2019?
1,500-foot separation from non-restricted licensees. Yep. Thank you.
Thanks. Appreciate it. Anybody else down here in Las Vegas? Sarah, anybody online?
If you wish to provide public comment, click the raise hand icon at the bottom of your screen or dial *9. There's no public comment.
May I make a quick statement? Yeah, Chris Anderson for the record. I just want to address one thing that Ms. Valentine mentioned and give any folks in gaming comfort if they're watching this proceeding that the 1,500-foot distance just restriction between cannabis and gaming is very much a feature of this framework. And so we no change from the way that any cannabis establishment has to keep its 1,500-foot distance from a non-restricted gaming licensee.
Anything else? This is.
Look, another thing I'll say, I mean, I think we've talked this a little bit to death, but I'll just say, look, this is this isn't going to be everything to everyone. We always intended for this to be a little bit of a narrow trial balloon for Nevada to dip its toes in the water on what consumption would look like at public events and in a live entertainment setting. And I think this is obviously, we've worked toward an exceptional framework for making that happen while giving a lot of stakeholders comfort that we've been as malleable as possible in trying to address everyone's desires and concerns. Thank you.
Thanks, appreciate it. All right, if there's nothing else down here in Las Vegas, then we'll move on from agenda 2 to agenda 3. Solicitation for possible amendments to the NCCRs 1 through 15. And this one, I'm going to go through basically each reg. However, I know a lot of things will overlap, so just jump in where the majority of concern is for that reg. I want to point out one thing I want to talk about is we had a lot of comments on the agent cards, having to have multiple agent cards. We don't disagree. We're looking at that as well. We're looking at that will take a statutory fix, though. I know someone mentioned that they didn't think it would, but that will take a statutory fix. So we are looking at that for a potential BDR at next session. All right, let's go ahead and start off with Regulation 1. Did anybody got any comments on the definition section? Didn't think so. How about, maybe we do.
Hi.
How you doing?
For the record, Abby Kaufman. So we, as the Chamber of the Commerce Committee, we collected a lot of feedback, and for Regulation 1, the main one that came up and I saw in the other public comments that were posted ahead of the meeting as well was about the definition of a lot, especially in 1.125, the subsection 1. For like right now, it really causes an unnecessarily high burden on the cultivators, like financially, because you have to pay each time, and then also operationally, it creates a lot big logistical headache of trying to take up the space, and especially when you're having to track everything so meticulously, and then you're having to break it up that small. That's time consuming, it's inefficient and costly. And from my understanding from one of our committee members, California's regulations define them as no more than 50 pounds, which is 10 times ours. So we were proposing in the comment to increase it to at least 15 pounds, which is the same amount as subsection 2 for leaves or other plant matter.
Thanks. We can leave that to Kara. Kara's got a good statement she wants to make on the law says.
Sure, yeah, Kara Cronkite for the record. I just want to let everybody know that we are having a workshop specifically for laboratory testing in March. Additionally, we're working internally really hard on trying to streamline a lot of these testing requirements. Some things we're taking into consideration is the lot size. We're going to reach out to the other states that have higher lot sizes. We looked at BOTEC, which is where these initial limits came from. They released new limits in 2023. Unfortunately, they didn't increase them. So we're going to keep looking for other sources and see if there's any potential risk to public health or potency, accuracy, or anything like that. if we do increase, but we are looking at other ways of streamlining these testing requirements while considering the route of administration and those risks. And if certain tests aren't really relevant to that route of administration, maybe we can streamline it that way as well. So I do want to let everybody know about that. And again, we will be reaching out to the other states to learn more about lot size increases and potential benefits and risks. Thank you. Thanks, Abby.
I'll explain it real quick. We're going to have a packaging labeling workshop. Hold on a minute. We're going to have a packaging labeling workshop next month and the next month. That's actually going to be our first official APA workshop. We're also going to do a laboratory workshop in March. Again, this is a follow-ups to those of you that came to the prior solicitation inputs last year. Those are going to be our first official APA workshops, and we're going to move those on it again as soon as we're ready, which I believe will be the end of this month or the end of February. But please feel free to continue giving me comments on packaging and labeling and laboratory issues, because we can, if there's anything we can implement those in the next workshop.
Amanda Connor for the record. And I don't know if we're really intending to go item by item, but if so, I do have comments on definitions. First, 1.052 advertising and advertise defined. After this was adopted, there was CCB guidance that sent out a new definition and distinction of advertising. That was issued on January 18th, 2023. It's my understanding that the new definition that was sent out via listserv is what's actually being implemented. Therefore, I would recommend updating that definition to what was in the listserv.
Hold on, before we move on, I guess you know that one?
Yes.
Yeah. Steve, you want to go ahead? I think you wanted to address that.
Yeah, Steve Gore for the record. Yeah, thank you, Amanda. And that was, I don't know if it was your comment that was submitted, but somebody else submitted that, and we'll take that and put that on to, that'll probably go on the next month's workshop for packaging and labeling, I anticipate, and we'll see if we can get that at.
Okay. 1.081 conditional license defined. I believe that definition was adopted related to lounge licenses. However, as the board may be aware, or staff, there are times when licenses are reverted back to conditional license and issued conditional. Now, I get that it limits the reference, but if they were reverted back to and a conditional license issued subsequent, I'm not sure this is supposed to apply, or maybe it is, and they're supposed to go through a suitability review again. I just think I wanted to put that on everyone's radar to understand.
Appreciate that. We were thinking people that get reverted to conditional for a long time, they're going to go through a little analysis before they're allowed to start back up again.
Okay.
But it would be something minor, not the whole huge suitability review.
1.082 derived, at least the adopted copy I have has a reference with X's in it. 6.7 or NRS 678A.XXX. I think that probably should have been referenced.
6.7. Which one again?
It's a definition 1.082 derived. It says for purposes of NRS 678A.XXX.
Yeah, that was a placeholder.
That didn't fill in, right?
Yeah, thank you.
I did not take the time to look it up, so I apologize, but there is a placeholder there that. Right.
I'm hoping we can just incorporate that into statute, but we'll see what the legislators accept.
And that's why we put it in, right? Because we were ready. It was
Bill 49,
yes.
but yeah.
Right.
It didn't go through yet.
And on definitions, section 1, that was my main comment.
Good. Anybody else on section 1?
Hi.
How you doing?
Yeah, Danny Baranowski for the record. I own a small business and represent brands and position them to win for consumption lounges and otherwise, but very much excited about the economic opportunities that's going to bring. You know, we've been working hard for years on that. I wanted to touch on 1.222, single-use cannabis product defined, hoping to seek some clarity when it comes to really defining what, when it says section or number 5, edible cannabis products in liquid form must be homogenized and dispensed to and sold to consumers utilizing a commercial weighing or dispensing device. I'm looking for some clarification on, for example, if I have a bottle of a spirit that does not exceed the legal limit, it's 100 milligrams, but it does have a dosing device, and I wish to make, for example, a cocktail, a cannabis cocktail. When we're talking single use, is it possible for the bud tender or whoever is serving and dispensing the drinks to then create a ready-to-consume product from the 100 milligrams into a no more than 10 milligrams portion, really giving people the discretion to choose their dosage, but also really eliminating a lot of waste, economic burden, cost. It's, for example, if we're asking a bartender to use mini bottles instead of full bottles, it's just going to be extremely cost intensive. We allow consumers to make, their decision on dosage. But with this language here, commercial weighing or dispensing devices, I think there is an opportunity to mitigate that without putting this extremely, wasteful.
I believe you were set up that way. So what else?
Yeah, so let me make sure I'm understanding properly before I try to answer. So you're talking about buying a 100 milligram bottle with 10 servings in it and using that to make ready to consume items and using that basically as a bulk item to make your ready to consume items?
Yes.
Yes, that would be perfectly fine.
That's perfectly fine.
Yes.
Okay, excellent. Thank you. I really appreciate the clarification.
Anybody else on regulation 1? Sarah, online?
You have comment online? Will Adler, go ahead.
Hi, thank you. Referring to my written comment as well, the regulation 1 does have just a couple, glaring sames as it has been since 2014. The first one is the lot size, as we've mentioned before. I did do a petition through the Sierra Cannabis Coalition, I think a year and a half prior on that subject. As it was already petitioned, it was referenced that we would have a workshop on that last March or February, in fact. So I'm just clarifying that that will be included in the discussion of the workshop this March. And then I was going to ask, how's it work with the third party firm? Are they going to just compile, sameness from other states, like same laboratory style regulations, and do a comparables to get us some sort of, Nevada amongst our neighbors? Or is it sort of just they're there to do a deep dive into our regs as they are today? Because it could be helpful just to do a regionality as referenced, because there's a 50-pound lot limit in California, and there's sort of differences Colorado to Washington and Oregon as well. But it might be good to just have a good census for what regulations are out there in the region.
So I'll let Kara respond to that one. But she was referring to a study by a independent organization. So, but go ahead, Kara.
Yeah, that document's Botech. That's where that was pulled from. But are you referring to the laboratory COAs database that was mandated by legislation?
That's a good one. No, I forgot about that law, but we did pass that. So, we should touch on that.
She's talking about lot sizes again.
Oh, okay.
Lot sizes again. No, just, my comment is pretty simple. It is referring to Washington State. They did an update in 2022. They did a very in-depth analysis of sort of the region, how it operates, and what efficiencies could be there. They went from a 5-pound lot to a variable lot size. It goes from 5 to 50 pounds, but it's very well thought out. It actually has sampling sizes and sort of, demarcations of needed, extra sample sizes for a larger lot, very, very well thought out and well broken down. So I just wanted to sort of start with maybe talking about what our neighbors are doing, what has been done since 2014. I don't think there's one silver bullet. I think Nevada is actually very different from Washington State. We don't have a lot of outdoor grows, but there's a lot we could look at just for a general update, or looking at what is relevant compared to when we first wrote it in 2014.
Yeah, we will be looking at what all the other states did and seeing if there's anything we can incorporate. And we will be addressing that in the March workshop as well.
Okay. And I forgot about that law. So good job, Mike. Hit that too.
I'm interested on people that are requesting increased lot size. I mean, we're going to talk about this obviously in the laboratory workshop in March as well. But and also increasing the lot size, especially, I mean, I know we're not actually considering 50, but even moving up to 15, that's a much higher risk of if it fails, you're losing 15 pounds instead of just 5. Also, it's going to require increased testing if it's, you know, a 15-pound lot compared to a 5-pound. Just things to think about. I've never heard, other than labs, too many people discuss. But again, we're going to discuss this again in more detail in the lab workshop in March. So again, I appreciate all the comment on it.
Yeah, and Will, I think that BOTEC study I'm referencing is the study that was done for Washington State, and they chose to increase the lot sizes against the recommendation of BOTEC, but I'll get clarification from Washington.
Yeah, I think it was the BOTEC study to jump back in there. And then I might not be here a little bit later. I have to jump into a meeting, but I did have comments on delivery, standards and sort of what the delivery regulations state today. Through Senate Bill 277, Dallas Harris's bill, we did increase possession limits from 1 ounce to 2.5, or sale amounts to 2.5 ounces. I just didn't know if there was an automatic, reference to the delivery standards, as we're stuck at 10 ounces per single delivery driver per trip. But I think that needs to be substantially increased to maybe multiple pounds, just for the business case or viability of delivery as a business, but also to reference the increased amount in a maximum order to have the same number of trips we have today. But just getting that in there now in case I'm not around later. Thank you.
Yeah, and I can address that now because I know we got a lot of comments about that. So the delivery limits was not addressed in the bill when the possession limits were increased and the transaction limits were increased. But that is something that we have the authority to change just in regulation. So that is something that we're looking into currently and finding that right amount where we're not increasing the risk to public safety, but also allowing deliveries to be profitable and not a waste of time.
We are likely not considering pounds because again, we're talking the driver is going to have what, $25,000 on him driving around. That's probably
I agree.
Considering how many robberies we've already had from delivery drivers.
We get a lot of robberies.
For scientific reasons alone, we should use kilograms. I agree. So yeah, continue.
Noted, Will. Thank you.
Anybody else on Reg 1? Anybody else online?
Glenn Miller, go ahead.
Yeah, no, this is some of the same issues that Will Adler mentioned. I was on the original ILAC committee some years back, almost 10 years ago now, and this issue came up then of what size of the lot size should be, and I think most of us, there was lab people on there, but I always thought that the 5 pound was way too small. Because the cost of the cannabis is high enough now that it encourages illegal production of cannabis. And so I guess the argument I've always made is that we're looking at risk reduction to the user of this material, and risk reduction involves a cost comparison with illegally made, and is the cost of increased and the analytical. I'm an analytical chemist by training, and the costs of the analysis are quite high, and there's issues about what limits there should be on various contaminant loads. But the lot size, I think, is way too small, and it unnecessarily increases the cost without reducing risk. And I think that's the issue that I think we all want to see, is to have a product where you minimize the risks. And one of those risks is pushing people into illegally obtained cannabis. And that risk is not trivial. I mean, I know California particularly does have a major problem with illegally sourced cannabis. And that illegally sourced cannabis has rarely ever really gone through any of the protocols. So I think it's really important to consider this seriously. I agree with Will Adler in that kilograms is a better use, a better number. And that kilogram quantity could be taken up to 25. The lot size issue comes up always in analysis, whether it's soils or grain or a various crop, to get how do you minimize the amount of samples required to have a certain amount of risk reduction. And I guess I would argue that a 5-pound lot is way too small compared to the other risks involved with illegally derived cannabis. And I think 15, 25, even 50-pound lots could be considered, as long as the same strain, the same room that's grown in, and there's a homogenized sample that's taken carefully. But this is a problem that's existed for a long time in analysis of food products and various other things. Is how do we know when we get a sample that is going to be representative of that lot? And you can certainly do it with 5-pound lots, but the cost of that, I think, forces people to look at less expensive sources. But I think, and this is a problem that many analytical analysis have answered. Soil analysis. You go through a field, you don't collect every 5 pounds of field in a 20-acre field. You randomize it and have a protocol for selecting a soil sample that has representative of the analytes you want to measure. The cannabis species is the same. So it's an issue that people have come up with, and I think the lot size is way too small and increases the cost and increases the risk for people that are using illegally derived cannabis. That's all I want to say. I'll be at the March discussion too, because I've the ILAC committee. I thought, but just one of the complaints I had, the rules were made, and then they asked if is this okay, and very often our answer was no, it's not. But then it was too late to change them, and it's. I think this is worthy of significant thought, because you can price reduction and less competition from illegal cannabis, perhaps. Thank you.
Thank you.
And also feel free to say ditto if you have the same comment. Anybody else have a comment on Reg 1? Sarah? Anybody else online?
If you wish to provide public comment, click the raise hand icon or dial *9 if joining by phone. There's no additional comment.
All right, let's move on to Regulation 2, which I'm guessing we're probably not going to have too many comments on. Anybody have any comments on Regulation 2 here in Las Vegas? Online, Sarah?
There's no online comment.
Move on to Regulation 3. Any comment here in Las Vegas on Regulation 3? I think so. Sarah?
No online comment.
Let's move on to Regulation 4. I will state Regulation 4, we have almost completely rewritten. We're going through it. We're having the board go through it. We are going to send it out to certain individuals to take a look at and give us some input before we submit it for a workshop. But this would probably be the next workshop, maybe April, May, June, somewhere around there. We've added a couple categories in the new one. So the top category is just going to be the most severe penalties, like for revocation, and then we moved on down to category 7. Including with obviously lowering the fines as per statutory requirements and adding a few other things like the conviction waiver that we've just put in procedures online. That'll also be in that regulation as well, along with a few other things. But if anybody has any comment on the Reg 4 as is, please feel free to step forward.
Good afternoon, Amanda Connor with Connor & Connor. For the record, I appreciate that Reg 4 is being rewritten regarding discipline and hearings. I won't comment on that with the understanding that's coming out. With number 4.0, 065 imminent health hazards. Currently, the standard is that it must be reported to the board within 2 hours of discovery, including, loss of power, refrigeration. I understand the health and safety concerns with those, but in July, when it's super hot and the air conditioning or the power goes out for a minute, comes back on at 2 a.m., it causes a lot of people to be up, right? And I'm not sure the board is reviewing them at 2 or 4 a.m. And so I would propose that it be 24 hours. Almost everything else that's a serious incident has to be reported to the board within 24 hours of discovery. And therefore I would recommend changing from 2 to 4, because otherwise, or 2 to 24, because 2 hours is a very short time to file an incident report, especially late at night incidents.
Don't disagree, but I know Carol probably want to respond to this.
Yeah, and this is really similar to like what the health department and other health departments require. It's just for those imminent health hazards. Like if your raw sewage is backing up into the facility, or you walk in and it's like your production's kitchen is just infested with cockroaches one day. Within 2 hours of discovering that, I think that we should be aware, just so that we can help guide you on, making sure that you're closing, making sure that you're taking the corrective actions that are necessary. If you have another recommendation, I think 24 hours is way too long to go.
I would say a little longer than 2 hours. I recommended 24, but for instance, I know a client that had a fire and they were literally trying to get employees out to safety and someone on the phone with me because we were getting close to the 2 hour mark, and yet fire is still there trying to put stuff out. It seems like public employee safety, getting people out of the building should take precedent over making sure you meet the deadline, but it's a violation, right? And a pretty significant violation to not report within 2 hours. So even if we're not 24 hours, maybe we make it, longer than 2, or 2 once, everyone's, however we can phrase that.
Situation has been
resolved.
Okay.
Yeah. And again, I think, if the facility's not open for business and they discover it at 2 a.m., which a lot of them do, because if the power flashes off for a couple minutes, they get alerts because of their alarm systems, cameras, everything else. But then they're up at 2, 3, 4 a.m. And I'm not sure that's the same public health safety issue that we're looking to address with imminent health hazard. Okay. So just cleaning up some of that language. I get the purpose of the notification and the reason, but I think some of it, is pretty.
And part of that is we can't cover we're not, obviously we would not bring charges against someone that are still putting out the fire. It's 2 hours and then give us a call. That just wouldn't happen.
But I understand it's not something you should be worried about.
Exactly. And you really shouldn't be worried about it.
You shouldn't be worried about it, but the rule says, right? Yeah. The other one is 4.140 and 4.145, the petition. I simply would propose that there not be a fee charged with petitions. So filing for a petition has a non-refundable filing fee of $500. I think there's a lot of people that have some very great ideas about regulations and options and or way things should be in this business. And they're maybe unable to participate because of some petition filing fees. So I would recommend getting rid of the filing fee. And then that's it on.
Hopefully we'll have the new reg 4 out to several of you here in the next, I keep saying the next couple of weeks, but I really mean it. Hopefully it'll be in the next couple of weeks.
Abby Kaufman for the record. I would like to echo what Amanda said about the petition fee for removing that, specifically for the 4.145. It's great that this workshop is happening today, and the scope would give an opportunity to talk through all the regulations, but there hasn't been a workshop like this covering that scope since I think I saw the last workshop was like with all of them was in December. It was the first workshop the CCB ever did. There's always a defined, and usually it feels reactive to a statutory change.
Yeah, one about a year ago. So we're going to try to do these yearly.
With
everything was open.
Okay, I didn't see that okay, or maybe, okay, other than that, but there's very few.
Involved with the governor's directive is the reason why we did it. We opened it all up for everything.
Oh, for submitting.
Yeah, but we opened it, yeah, but.
Right, but
we're gonna try to start doing these like yearly if we can.
Yeah, that would be fantastic because, and even with this, which is a fantastic opportunity, but it's also coming the day after the quarterly reports are due from like license holders. And it literally was less than 2 weeks ago on the 18th, I made public comment about removing the petition fee. Then this was announced and I was like, great. But wait, that's like that's less than 2 weeks. So at least if the time constraints or somebody's dealing with an imminent emergency, at least the industry can have the opportunity to provide their input and have the public conversation without piling $500. And then this one might be, I don't know if this is, I'm not a lawyer, obviously, I'm not a lawyer, but is there in NRS, in Title 56 of NRS, like it outlines the fees that must be deposited to the state general fund, and it talks about administrative expenses. Are civil penalties considered fees or administrative expenses, or is that a separate category?
They have been, and they have been going directly into the school fund, whatever we.
But like, so historically they have, but like per statute, like, do they have to, like, is it possible? And I'm not sure, but if it's described as a civil penalty, like it'd be nice at some way, and as we're reviewing the regulations, if understanding that part of the CCB's mission is to, help the economic impact of the state and all that, if there's a way to find opportunities in the existing fees that are being collected to set those aside in some other way for like the consumption lounge licensees, or have some kind of way for the state to help support the operators as well. And that one, again, I don't know if there's a legal difference between fees, administrative expenses, but I didn't see civil penalty mentioned when it's talking about like in the NRS.
And I said, I like what you're thinking about, but anything we try to take away, they're going to say we're taking away from the kids in the school fund. So something like that would need to be a statutory change, because again, this is all handled through a budgetary process that's 2 years in the making.
Right.
So it would need to be a statutory change for us to do something like that.
And so the school fund, like, so isn't there kind of like a cap, or I guess I'm not as familiar with the structure, so I'll follow up on that later. But yeah, I think those were my only 2 comments for regulation 4. I do have some for 5, but I don't know if anybody else has 4.
See you.
Thank you.
Thanks. Anybody else want to talk about regulation 4? Surprise, surprise.
All the way in the back. Thanks again, Mike Martin, Nevada Cannabis Association. I wanted to echo Amanda's comments regarding the amount of time to respond. There's all over the regs, there's different times to respond. Some 12 hours, which we referenced in Reg 7, some are 24 hours, some are 2, some are immediate. And what we've heard from our members is that their first focus is the safety of their employees and addressing that problem. And so we have, in some cases, they're filing like an initial bare bones incident report just to get it done. And again, at the time they're dealing with an imminent health hazard or something like that that's happening. And so I just wanted to ask that we could look at those maybe holistically, either push them all to 24 hours or something. Just, it is an issue that, we have licensees who want to comply. Yeah. But at the same time, we're worried about the safety of their employees and the product.
Yeah.
In the accidental, like
I can look through them all and try to make them more consistent. And then anything that's very urgent, I can put in a caveat that after emergency has been resolved or something like that.
That would be incredibly helpful.
Okay.
It's immediate, right? Like,
No, and I saw it. It might have been you, but somebody submitted a comment about a vehicle accident and they were, focused on telling us, and that's not what we were hoping for. So
yeah. No, valuable. Thank you. Okay. And the other, and we addressed this in our written comment, but just not knowing what exactly is in the regulation 4, just highlighting the legislative direction to include disciplinary violations for unlicensed sales.
And you also understand the APA is involved now, and we probably aren't going to see our first change even from the packaging labeling for a long time.
Yes, I just, again, making sure that hopefully that those are included and that we have the opportunity to provide input. It's such a huge problem facing the industry and has been. And now we're looking at intoxicating hemp products as well, being sold out in the open on Fremont Street. You know, how are we addressing this and making sure that before we're adding additional penalties for licensees, that we're looking at penalties for unlicensed companies.
Yeah, that's also going to be in the Reg 4 update that hopefully will be out in the next.
Perfect. Thank you very much.
Thanks. Anybody else here want to discuss Reg 4? Sarah, online?
To provide comment, dial *9 or click the raise hand icon. There is no online comment.
Great. Let's move on to Regulation 5. Anybody got any comments on Regulation 5 here in Las Vegas? Oh, you and Lakeshore Park.
Good afternoon, Amanda Connor with the law firm of Connor & Connor for the record. With regards to Regulation 5, I'm just going to put out there that it was mentioned at the November CCB meeting, and I think it's been commented other places. Dave Staley and I and some others have been having comments on transfers of ownership, public traded company disclosures, tracking, and needing some updates. I know Dave has been, I think, working on language. I would just put out there that 5.110, 112, some of those definitely need some revision and work to do that. Also need reflect the last legislative change regarding agent cards and not being required for owners less than 5%. But I don't have the exact language of what that should be, but I do think we need to look at that.
Again, I hate to say it, but APA will get there. We don't even have, the NCCRs hasn't even been transferred over to the NACs yet. So this is going to be a long time process.
I realize that, and with with the ownership, right? It's been an ongoing discussion since the very beginning when medical came, and it's just making steps and strides forward. But
and you guys might want to push again, because again, we try to push is the above 5% to be able to do waivers for, like, especially holding companies above 5% that have passive investments. I mean, that's got to be a statutory change, but I highly recommend that come from you guys.
noted.
Anybody else want to discuss Regulation 5?
My name's Tina Skellinger. I just actually represent myself in the industry. I've been in the industry since 2016, primarily in the cultivation and production side, where I have repeatedly and excessively had issues with agent cards and the cost and the expense of agent cards. Primarily working at small businesses where you may only have part-time hours, and say that same employee that just trimmed a flower has to get another agent card to put it in a jar. Now, I don't think people understand when they made these rules up that the people that are being affected the greatest are on the lowest rung of the ladder. These are employees that are making $15 an hour, and to get a promotion, they have to fork out $300. That's not really encouragement to stay in an industry where you're going to have to fork out more money to get a better position, to move up, to cross-train employees. It just makes it very difficult. And I've looked at other states and other statutes where it's not, thankfully, they changed it from 1 year to every 2 years. I appreciate that. Thank you very much. But even for record-keeping purposes, prior to the cannabis industry, I was in the auto industry for 10 years, dealing with VIN numbers, insurance ID numbers, and et cetera. Us changing the agent number repeatedly, I find would make it difficult for record-keeping purposes. Just keeping track, people that have been in the system, if their number's changing all the time, it's kind of hard to track where they are and or what they are doing. But if they had one number associated to that one person, it just makes a little bit more sense just to streamline it that way. Why would one person need 3 cards that's only making $15 an hour? And I'm just asking to
Well,
either,
this is the
Yeah.
comment I made earlier. I mean,
Yeah. Oh, I know.
we understand and we completely understand.
Well-
We're looking at it. It's got to be that part of it, the multiple cards has to be a statutory change. The other part is something that we have been looking at. We just, it's, down our list. And
Well,
as we're getting through things, is the individual number for an individual person. So it doesn't keep changing. So basically it's almost like a driver's license for.
right,
We want to do that too.
keeps
We
your
just-
record.
We just haven't got to that point where we got that done yet.
Like I said,
We are
just for
working on it.
record keeping purposes. I've
agreed.
worked as a title clerk and a notary. Keeping that same number makes a lot more sense than changing it every 2 years.
For us as well.
Who thought that made sense? I don't know, but it doesn't. Just logically, no.
And I think it's the system that we were permitted to use.
I know it had something to do with like just keeping track of like, what was it explained to me as like renewals and so on, like your number was affiliated with your expiration date. They knew if you gave this number.
Yeah, and I think
The
it's
expiration
the
date should-
system
yeah.
that we're tasked with using, but Steve Gilbert can add anything if he has anything, but it is something we're aware of and we.
Last
would
question,
prefer-
last question / comment. In the actual verbiage, it says they can charge up to $150. Why have they chosen to choose the maximum amount and not chose to?
It's listed under there in the statutory up to maximum amounts, but then also right underneath it, it gives the limited circumstances of when they can reduce the fees. And this isn't one of those cases. So we have to charge the maximum. The fee is the fee.
That's about it. Thank
Appreciate
you.
it. I know, Steve, I know spearheading and wanting to create the one number. I don't know if he wants to talk about it at all right now, but.
No, I'll just, I appreciate the comments and it's something that we're really looking into deeply right now. We understand the burden on the employees to get multiple cards, the multiple costs. I just want to assure you that we are looking into it. We are suggesting some different language in the statute, which requires a statutory change to reduce the number of cards that are needed. So again, we understand the concern, we're addressing the concern. Hopefully we can get to the result that everybody's looking for, but we do understand and we're working on it.
And I don't know if it was your comment or please come. I don't know if it was your comment or someone else's that also talked about the lost card fee as well. As we lowered that once already and we're looking at that again. So see if we can lower it again, but we've lowered that once already. So we're looking at it.
Hi.
Hey, how you doing?
I'm Peggy Shaner. I'm with the Chamber of Cannabis on the Board of Directors. And I'm so glad to hear that this now has become a situation that you're taking a look at. I've given you my written comments that you can read, and I hope you do. But let me just, because everybody is on the same side here, it's wonderful. I just want to give you an example of what has happened with me. I'm an accountant for the industry. I have several clients that I keep books for. In one case, a young man in his early 20s was just released out of foster care system. As many of these young men and women, they don't have much in the sense of self-confidence, self-worth. They start at a minus ground and don't go up from there. But I lent him the money to get his first agent card. Now, this is a kid that knows every step of the marijuana process. He's been in it for years, okay? He knows how to trim. He knows how to do production. He knows everything. I gave him the money for the card. He got a job in a vertical what do you call it?
Vertically
integrated organization, and he began work part-time. In order for him to get, more hours, he wanted to help out in production, which was right across the hallway from the trim room. Now, he couldn't do it. He didn't have the money for an extra card. And what I did was I lent him $150 again to get another card. You would have thought I gave him $1 million. This kid was so happy, and develops their self-worth, their self-confidence. They become more valuable to their employers who, to this point, cannot manage their human resources efficiently, economically, because in production, somebody went on vacation, they're not well staffed. He's sitting in the trimming room like this, biting at the chomp, wanting to help him out, but he can't. So the employer has to pay overtime for somebody to stay and get the job done in production when somebody else in trim is just, wanting more hours and so forth, so on. So it's the cross training. And I am advocating for a more inclusive and supportive approach to encourage cross-training and foster the employee development by removing the financial barriers that we now have to face, and to allow the employer to develop a more educated and worthwhile staff that they can have well-rounded, who can work in this industry and meet its diverse needs. So thank you very much.
Absolutely. Thank you.
Again, that's what you were saying. We are working on that. We are looking at that. I don't know that we can do it. Again, it's statutory requirement, but we are definitely looking at it.
Not trying to beat a dead horse, Abby Kaufman, Wheels. So if I'm still not convinced, again, not a lawyer, about the wording. I did pull it up and I do see what you're saying about for 5.1 for the agent card fees. But one note is on the language of the CCB website, and this is just nitpicky, but it says the cost is $150. I really find it hard to believe the cost is $150. That's what the CCB or the statute is requiring to be charged. And
so the legislators are trying.
Yeah. But on it's cost. And so speaking of the actual cost though, so what about for the requirements for a replacement card? Right now, it's an application fee of $75. If you think about the actual goods, the background check's already done. And if you think you ship it in state, $10, like that should be no more than $40. So that's, it's 30 some odd dollars and only for a replacement, but that seems somewhat feasible. And the other, I think that was the main thing. Assume if the CCB's hands are truly tied with the maximum with the per statute. So, but renewal fees, like there's replacement for a lost one. Oh, sorry. The other thing too is the reattestation piece. That's supposed to be done like midway through the year if the card is for 2 years, but then they have to if they have not changed anything, then they have to reach out and say that they have not changed anything, which just seems like kind of the other way around. Like if you change something, then you let them know, but why does everybody have to do that I
understand. Steve, you want to?
Yeah, sure. So on the reattestation, that's actually word for word out of the statute.
Okay.
And it's 678B.340. And if that's to be changed in regulation, that statute needs to be changed. So I encourage, to go to the legislature and try to get that changed if you desire.
Okay, thank you.
Anybody else on Reg 5 down here in Las Vegas? Nothing, Rusty?
Ask me, I'll ask. What does, on any of these regulations, 5, 4, any of them that we've gone over before, is there any intent to submit them to the LCB for approval pursuant to 233B?
These are all going to be, any changes other than the events. Events is one of the last two holdovers that we were working on well before the legislation. Everything else it's going to be through the APA process. So,
So what are we doing in the interim? So for all of these claims and all the enforcement that's going on right now, what's the position of staff as to the enforcement of those NCCRs?
Oh, they're all still enforceable. They're all just going to be shifted over to the NAC anyway. They're just going to change numbers. So And we're already taking into account statutory changes like the max penalties, so.
And so have the NCCRs been submitted to the LCB yet?
Yeah, they're converting.
They're supposed to be converting to the NAC. Last I heard, I can say it was supposed to be done in September, but that was an unrealistic expectation there. It's going to be a long time before these get shifted over.
So the second question is, any of these new regulations that we're talking about today, even for temporary licenses, that sort of thing, have those been submitted to the LCB?
No, the temporary licenses are prior to the statute, and by the statute, we were allowed to continue on with anything that we were working on prior to. So this, and then I think there was one other thing that we're working on that we're going to submit the old way. Everything else, all these changes that we're talking about today is all going to be through the APA process. So then so right now, this isn't even a workshop for this. It's just a solicitation of input. So the next, in February, we're actually going to have our first APA workshop. March, we're going to have another one. Probably April, May, we're going to have another one. And those will be as per the APA, and we're going to submit everything to LCB.
And so each different regulation will be up subject to review and subject to those workshops in February, March.
Well, the everything in the packaging labeling.
Okay.
All right. But I can't tell you when it's going to get converted, when it's going to be adopted, or when it's going to be converted to the NAC. That I do not know.
Thank you.
Anybody else have anything on Reg 5?
Just on the topic of, sorry, Sarah Adams from Planet 13. On the topic of agent cards, I understand what you're saying about you need statutory change in order to, for all the things that were discussed. But the concept of, so I have a board member that I'm about to add, apply for agent cards for. And currently we've got to submit fingerprints for under the medical statute and under the recreational statute. But because if we're a dual licensee, our licenses are effectively combined effective January 1, is it not already permissible to just nix one of those fingerprint requirements and just submit one set of fingerprints?
Yes, I believe so. Steve, you want to respond?
Yeah, and that's something we're looking into. And I did see your email the other day. So this is a unique situation where we're combining some of these licenses now and then combining some of them later on, depending on the renewal dates. So we are looking into this. We are going to get some guidance out. I appreciate you asking this question because it did raise the issue for us. And we're looking into it now, but we will get some guidance out very shortly. And that's not going to require any statutory or regulatory change. Perhaps it would just be on the agent card application itself. But also your scenario there, is that for a prospective board member entering?
Renewal?
Prospective, yeah. He'll be joining
Prospective.
next week or something, yeah.
Yeah, so your situation is also unique to a prospective owner, officer, or board member coming in either through a TOI process or being added to the board. So we'll look into that with the combining of the license, but for a regular owner, officer, or board member has a history of being an agent card owner, this shouldn't be an issue for that.
Okay, sounds good. Thank you so much.
Anybody else have any comments on Regulation 5?
Hello, good afternoon. My name is Katrina Saunders, for the record. I'm representing myself and a longtime patient and advocate in the industry in regards to you guys speaking about fees for cards and regulations. I've had my card before and then it was taken away from me, and they just wrote this bill SB 277 to help mitigate some of that.
It's on the website now.
Yes, it is. So I saw the petition on there in regards to that. So with you guys saying that you have to put a petition in whether you want ownership and what position you're going to have in the industry. I don't know what position I'm going to have in the industry. So now hearing this, I have to apply for multiple cards as well with the additional fees. Yeah,
if you were going to work at the way, again, it's set up right now statutorily, if you're going to work for a cultivation, production, and dispensary, that would require 3 cards,
Correct.
which would be $450.
Right, which is an egregious being back on your feet after being affected by the drug war from the state of Nevada. I think there should be a fund set aside to help mitigate some of those costs that people have to deal with, like myself, as being affected personally by the state of Nevada. They should be helping some of those fees. Since the last time I applied, when they denied me from changing the law, they kept my money from that and I never got a card. So I think that should be looked at as well. Thank you for your time.
Thanks, appreciate it. Anybody else on Regulation 5? Anybody online for Regulation 5, sir?
Provide comment, click the raise hand icon at the bottom of your screen. There's no comment.
All right, let's move on to Regulation 6. Anybody here in Las Vegas want to discuss Regulation 6?
Right.
Quick.
Good afternoon, Director Miles, Chief Contact, everyone. I am referring to my written public comment that I submitted last week on the 24th regarding Regulation 6.120. So members of the public, Regulation 6.120 aims to regulate the advertising practices of cannabis establishments and ensure responsible promotion with specific attention to preventing exposure to individuals under 21 years of age. So Regulation 6.120 pertaining to advertising restrictions for cannabis establishments should be integrated with the relevant information from 2 key bulletins: Cannabis Advertising Guidance dated May 14, 2021, and the Advertising Guidance from January 2023. So I propose consolidation I'm recommending to streamline access to critical regulatory details, preventing the need to refer to multiple documents. So you see my eyeballs just like everywhere looking for that. Wait a minute, I know I saw that, but it's not in regulations. And I have to go back to the 2 bulletins, you know? I can do that, but my clients can't do that. They don't have time for that. And additionally, the title of the Regulation 6.120 should explicitly include the word "and guidance" to emphasize its dual purpose in setting rules and providing direction for compliance in the cannabis advertising domain.
And we discussed that earlier. I think some of it is going to get changed in our February workshop. We got to be careful though. We don't want to put examples in the regulations themselves. So the example part of the guidance will still be held in guidance, and everything else that we can change, we will change in at the upcoming workshop.
But we did get your verbiage and several other recommendations, and I think there's a little bit of language that we could incorporate into the regulation.
Yeah, I agree. It's like just easy to look under 6.120. Everything is there, but guidance, I get that because it changes all the time.
Yeah, exactly. And especially nowadays where it may be a year before we can change regs. So.
Correct.
Yeah.
That's why we're here. Okay, so on the guidance, cannabis advertising guidance, dated May 14, 2021, I found a grammatical error. It's supposed to be reasonably instead of reasonable. So I thought it was confusing.
Which one again?
The cannabis advertising guidance dated May 14.
Oh, it's in the, okay.
Yeah, I thought that's just because I was writing and consolidating my own. But anyway, I thank you so much for agreeing. I don't think this requires any statutory change, though. Thank you.
Great, thanks. Anybody else on Regulation 6?
Deputy Director Miles. David Goldwater, representing INEO Fine Cannabis Dispensary. As we're just throwing out ideas in 6.070 is the visitor's log. It's a policy that seems to confound anybody who wants to be compliant. Sometimes we try very hard, and I'm searching for sort of the policy nexus of where I understood where the policy nexus was under medical, trying to understand it under adult use. And if this is a space where we can either refine or delete this regulation where there no longer is a compelling policy reason, I think this would be helpful for both the regulator and for us to be more compliant and shift our resources elsewhere.
Yes, thanks. Anybody else on Regulation 6?
I think there's a lot.
Amanda Connor with the law firm of Connor and Connor, for the record. I don't think any of us need to go over all the regs that need to be updated through statutory changes. So just putting on the record.
And most of
not-
those should be, I believe, are in the packaging labeling workshop coming up next month, so.
Okay, because like, for instance, 6.010, right, talking about maximum allowable quantities would need to be updated, or 6.025 on fees would need to be updated. But without going through those, a couple of comments, similar to David on 6.070, I actually have a little bit of a different comment. I'm bringing it here because this talks about visitor log, but I've had several conversations with Keoki Allen and other auditors where the regulations sometimes specifically call out and enumerate what is to be in the log, and other times do not. For instance, if you search the word production log, it is not in the regulations, or packaging log, yet when the facilities are being audited, they are being cited for not having those, or they not having certain categories, but it's not enumerated in the regulations what those logs are, what are to be on them. It's my understanding that the auditors have been trying to work on that, but I would recommend if we're going to have logs and audit the facilities for having them, the regulations should specify what's required. Separately in 6.080 subsection 8, talking about quarterly inventory counts and then significant variances. The regulation, Blake commented earlier, this one says immediately reported to the division or the executive director. My understanding and the instructions on the quarterly inventory reports are those are actually done quarterly, significant variances through quarterly and through metric cleanup process. Thus, it's not immediate, right? It's quarterly. So I would recommend that be updated to reflect the process the CCB has sent out.
I mean, so we want to know if there's a significant variance all of a sudden, like a large chunk has been stolen. So.
Yeah, I'd have to reread that
Yeah,
regulation,
we'll look
but
at it.
maybe like immediately report upon noticing, or report within 2 hours of identifying loss or something like that.
Well, so I think this is, and maybe that's elsewhere, right? So there's two parts here. So there's subsection B that talks about any significant variances being documented, investigated, and immediately reported to the executive director. I think we probably need a little more time than immediate because you have to investigate it, right? But subsection C talks about quarterly reports, but then says significant variances must be immediately reported. And in the quarterly report form, it doesn't say immediately. It says do it when you do the quarterly report and do a metric cleanup. So I'm just saying subsection C goes against what the CCB forms and guidance have been.
Tell me if I'm wrong, but I think that means if you discover it right away, if you discover the quarterly report it then right away. If you discover it prior to the quarterly report,
Yeah, I think B.
report it then.
B would cover prior, right? C is all about the quarterly report. So I think
we'll
we
just
just
need some
clarify.
language, just clarify. Okay, that's fine.
Sounds good.
And then, and probably not immediate, if you're gonna have time to investigate, right?
Right.
A little bit of time to investigate and verify.
Absolutely.
6.085 with regards to the security, just to put on the record, I would propose and support the idea that the external hard drives that the facilities are required to maintain and provide to the CCB, that upon the CCB doing their investigation, those should be returned to the facilities. They're quite expensive, and to continually have to purchase those to turn over video. I believe originally the intent was most of the video would be reviewed through the virtual access that was given. However, that has not been the case. Almost all investigations and requests are to put it on portable hard drives. So facilities are incurring costs and continually having to provide those.
We'll talk to RT. I know this is one of the things. If it gets connected to our system, we generally don't return it. So that's the problem with that.
And besides statutory updates, I think that was my main comments in section 6.
Great. Thanks. Anybody else have anything in section 6?
Excuse me. Good afternoon, Chair, members. For the record, my name is Timothy Eliotto speaking, and I just have some few comments or recommendations for Regulation 6, starting with NCCR 6072, in which it has in regards to training and instructions required before agent begins work. I feel that is pivotal because based on my experience in this industry, I'm just going to give a scenario. You have a cultivator who just basically, just let's say within a week is taken down, say 15, let's say 20,000 pounds, let's just say, hypothetically speaking, of cannabis. And all of a sudden they're one crew or two crew member down. And all of a sudden they need, some extra help within the harvesting crew. So urgently they will call for anybody else that could help assist. Unfortunately, when you're put under those circumstances, you don't have the training that pretty much an employee that might have been there for a couple of months might have had. So usually what happens is, with my own experience, I noticed that there's a lot of violations in terms of compliance violations in which occurs when we don't properly, give the new employees the necessary time they need to basically get on board with terms of the company's policies. And that's.
I will not disagree in any way, shape, or form that training probably prevents a lot of violations, and we highly encourage it. And we're actually looking at a different way of doing training ourselves. So.
To be honest, right? One of the biggest issues we have in the industry, it's unfortunately cultivators are, just being honest, they are producing products that are failing the microbial testing, honestly. Mm-hmm. Okay, so how do we mitigate that, or how do you fix that? You fix that by enforcing strict regulations in terms of production or cultivation. So let's say, for example, you have a lead who it's basically based on their expertise or experience. What I notice is that there's even a lack of procedures in place, SOPs in place for ergonomics, especially. You start your first day at work, the lead, based on whatever expertise or whatever it is that they have, they could literally, lead the new employee towards the wrong, direction, right? So I'm just basically stating that it's pivotal that we have strict measures in terms of hygiene. Very, very important. Hygiene within the cultivation facilities, man, oh boy. And speaking from experience, okay, I'm trying to stay on these policies because there's a correlation in line in which we have to draw if we want to be a successful, enterprise. So if we're failing microbials, then, or, mycotoxins, then how do we properly mitigate that? Basically, advocating for, labeling for radiative, cannabis, it's not the solution. That is literally the easy way out, because based on that, you no longer have to employ skilled employees. What the industry lacks these days is they do not employ skilled employees these days. Anyone that is willing to go through the agency for $12 an hour basically gets to work. We used to be an industry in which it's a skill set industry. You need skills to be a cultivator. You have to have the skills to be a cultivator. Unfortunately, that is no longer the case. And I think I'll just keep it short. And then also 6075 that touches back on the policies and procedures. I think that we need to basically prioritize those specific policies, and then also the CCB needs to take much more proactive action in enforcing those. So thanks for your time.
Thanks. Anybody else on Reg 6? You already used your shot.
I know, I can't say goodbye to sorry.
No
Didn't
problem.
say the Goldwater again. I apologize for this second bite at the apple. But I'm operating in, these are some small things that are less ball story. 6.087 is the requirement that everybody have a physical agent card with them. That's obviously understand the policy there. One of the issues that we have seen and amounts to a lot of lost productivity is somebody thinks they have a copy of their card or a picture of their card, and they think that is sufficient. We send people home, we have to fill in, we have all kinds of problems. If there is a reason for the physical agent card, that's great. It's verifiable, even by photocopy or picture. That would be something I might suggest. Some likeness and a valid card with the information available. I can help you with language. Thank you, Director Ma.
Thanks, appreciate it.
Thank you.
Anybody else on?
Yeah. Okay, so I know that a lot of some of these are statute and have been, I think there was some proposed revisions in October for 6.010, but I think there's still some confusion about the equivalency conversion for that, where like if 1 ounce of flour was 3,543 milligrams times 2.5.
So that's not exactly how it works. I can explain this, and I know where the confusion is coming from. So while the usable cannabis possession limit went from 1 to 2.5 ounces, the concentrated limit only doubled. It went from 1/8 of an ounce to 1/4 of an ounce.
Right.
So that was doubled. So we can't make that equal anything other than 7,087 grams. That is the conversion. That is what it's equivalent to. There's no other math.
Okay,
easy to pull that off.
okay, thank you. That makes.
But I can give an example to kind of clarify if you want. So like if you buy half your allowance in concentrates and then half your allowance in usable flour, for example, or pre-rolls or something, that would be your full amount. So if you bought 3,543 milligrams of extracts, then you have 1.25 ounces equivalent of flour left. So it's like the percentages. So don't look at it as an equal amount. You have to look at it as I purchased 20% of my limit here, so I have 80% of my limit left here, if that's helpful. I know there was a lot of confusion around.
So basically, like 1 ounce of flour does not equal 3,543 milligrams of THC. That's
okay. 1/8 of an ounce of concentrate.
Gotcha. Okay, that makes sense. Thank you for clearing that up.
And I believe Kara's put a chart on the website.
Okay, there is still some confusion amongst our members, so a lot of these are things that we've collected in the past 10 days. And then 6.025, I know that's statute that was changed with SB 195, but like I haven't seen the proposed language for revision, and I don't know if there's been any guidance or just like, hey, by the way, now we can't charge you guys for these things, or
Yeah, we stopped charging time and effort for inspections. It's just the only time and effort charges right now are investigations.
Okay, but just to like, I just thought.
As per the statute, by the way, this is
statute
overrides reg.
Exactly.
These regs are now hard to update. It's gonna probably be a year before you see a lot of these changes in the regs. But
okay, so in the meantime, I do think having like some kind of, it's a pretty detailed, like, I think that the actual statute could be almost like verbatim in a regulation, as I suggested in mine. But just to make sure, like, I'm sure that the CCB would never intentionally charge, but like, I don't know if all of the industry is aware of that. So just one note.
They have not gotten bills from us.
Well, it could be a good opportunity for some good press. And for 6.0.0, similar to the kind of phrasing of immediately, but the significant variances, one of the pieces of feedback that I received was that that's not super clear. And then also it's not, whatever system for tracking the significant variance might not totally account for the fact that cannabis is like a crop, cannabis flower is a crop. And so it'll adjust and kind of absorb and change based on its environment. And so the feedback I received from members was to request like just more concrete guidance and justification or explanation of the definition of significant, and just to not better account for the natural fluctuations of plant material.
Yeah, and we definitely take into consideration natural fluctuations. That wouldn't be a variance because it would be accounted for. So in metric, they can adjust for moisture loss, adjust for like trimming, maintenance of the plants, things like that, drying, that all gets taken into consideration. So as long as they're entering it properly in metric, which is our seed to sale tracking system, then that wouldn't be considered a significant variance. That would be natural weight loss. But if you're looking for a guidance document, that's definitely something that we can put out there.
I think that might be appreciated, and our member is on our board. He's had a cultivation emergency, so but that was from him.
Okay.
And he's provided more context in his written comment in advance as well. The other kind of last one for 6 is, I know this like in terms of the remediation backlog. So for 6.123. I don't think that it creates a huge bottleneck right now, but potentially including some guardrails for the turnaround time for the approval of packaging, just to, as the CCB's mission is to hold everybody the same ethics or standards as we hold ourselves and all that, just to have some kind of time frame for making sure that people aren't waiting for the packaging requirements, especially with all of these new packaging changes coming.
Have you experienced a large delay in packaging approval? Because usually they're like 2 or 3 days.
Yeah, I know.
Okay.
I would just in case, sure, the team's really efficient now, but will it always be? And as things are changing, and with that, just having some kind of safety net. But no, I did it was still suggested that I address it.
Okay.
But it was not something that in recent our members hadn't had an issue with.
All right.
Yes, thank you.
Appreciate it. Anybody else on regulation 6? Sarah, online, anybody regulation 6? Oop, okay, please, hold on, Sarah.
Hello, Sarah Adams from Planet 13. So on regulation 6.082, so that's where we are required to use, the seed sale tracking system for, selected by the board. And I guess by virtue of us being required to use metric, we are then required to, abide by like metric, just the functionality of it. And so essentially the metric user guide becomes part of the regulations. I'm kind of just, saying, but my problem is the metric user guide is not updated timely when there are changes made. And there are bulletins, everywhere, bulletins which cover various different topics, bulletins which have sections that do apply today and sections which have already been superseded by another bulletin or something like that. And so I guess my request would be, it just makes it difficult to comply with metric functionality when the user guide isn't up to date. And some of the user guide actually relates to, CCB preferences, and some of it is just functionality. But either one of those, I think it's important to actually have something in, like whatever the rules are that I'm supposed to follow. I really wish they would just be in one place. I mean, I know we're talking, there's certain things you want to put in the regs and certain things you want to put in other sorts of documentation. But as far as, the way that you're supposed to use software, I think it's appropriate for that to be in one place. And so it's not easy for me to find things in bulletins, unfortunately, sometimes. And particularly if something has been superseded, I don't think there is any indication on a bulletin, which is added after the fact, if it is superseded, to say, hey, this part doesn't apply anymore, or something to that effect. So
maybe like one single document that's like a living document that we update in real time to reference with current.
Yeah, that would be really great. And I know metric is big and they take a long time to update their user guide, but I mean, my hope would be that maybe, if a new rule goes into effect, I think the metric guide should be updated concurrently with it taking effect. And if metric takes, 3 months to do it, then it's like, sorry, it's not my issue that metric is taking so long to update their user guide. And so I would just really appreciate it being put, maybe, I mean, I don't know if this needs to go in a regulation or just in, some sort of internal policy, but I would just appreciate rules not being enforced unless they are actually in writing, so that we all have access to the same we all know what the rules are so that we can better follow them, I guess.
I'm assuming when our people are out there, though, they take that into account. I may go in the SOD,
Yeah.
but it's never going to go into discipline for something like that.
I know, I get what
that
you're
briefly,
saying, though,
but-
that it would be nice to have one
Yeah.
document to reference, and then maybe in the regulations, because say we lose the contract with Metric and we have to get another company, you don't necessarily want all that in regs, all that detail, because it wouldn't apply anymore. Or we'd say you have this requirement, but you're not physically capable of doing it. But maybe like a link to, or a reference to a document in regs that you would know to go to or something like that.
Right, okay. And then, I'm sorry, I was gonna say something else. Oh, so to your point about, I guess my concern isn't necessarily like only in the context of disciplinary action for not following like some new feature update or
Right.
something like that. But it's if I have a question from one of my cultivation facilities and I'm like trying to research and figure out what the answer is. In that instance, that's just where it's really difficult, where I've got to try and comb through, I don't know how many bulletins there are now, but like 70 or something like that. And so that in combination with the user guide, with the all states user guide, and then we have the Nevada specific user guide, and it just becomes burdensome, I think. And then I did just want to mention, so Amanda Connor's comment on the immediate thing in the reporting when you have a significant variance. I wanted to throw out there for your consideration. I think it says immediately once you discover a variance, but I would request that it's immediate or 24 hours or whatever the time frame is after, like not after discovery. Because if I, walk into a room expecting to see, 50 packages and they're not there, yes, I've discovered that they're missing in that moment, but I still have to go through an investigative process, like she was saying, but depending on the size of the facility, Planet 13 has hundreds of cameras. And so it does take us time to come through and find stuff. And sometimes we do find that those 50 packages were literally just moved somewhere else.
Yeah.
And so they're not missing anymore. So if I make a report to you that they're missing, now I have to go correct it and be like, no, they're not missing anymore. So my request relating to that would be, can it be whatever time period, whether it's 24 hours or whatever, from the time that an investigation is completed? And perhaps you could use the language like within a reasonable amount of time or something. And the board generally considers reasonable to mean within, whatever. And then it could still be like, there could still be a standard for the time, but it would also give you leeway to make it case by case in the event that you have a huge facility and it just takes longer to investigate, something like that. Yeah. So, okay.
We can look at that.
Thank you.
Thanks. Excuse me. Anybody else have anything on Reg 6? Sarah, any online comments for Regulation 6?
To provide comment, click the raise hand icon or dial *9 to raise your hand. There is no comment.
Okay, let's move on to Regulation 7. Anybody here in Las Vegas have any comments on Regulation 7?
Sorry, David. Good afternoon, Amanda Connor from the law firm of Connor and Connor. First, going back to just Sarah's comment, and there are some in this section as well, such as 7.050 that have immediate reporting. But as far as the significant variance, there is standard for kind of getting some definite context to timeline for reporting immediately, but giving time to look into it. So Regulation 2.050 subsection 1 says when you change your point of contact, you must update that immediately. And then it says right after it, immediately means no later than 24 hours. So, there is other regulations that have set the standard that give some time for looking into, even though sensing the urgency to notify the board. So same things with delivery drivers and car wrecks. I think you mentioned you had that story, and we really don't want people, right, that are in the middle of a car wreck now trying to handle.
Take care of yourself
Take care of
first.
yourself.
And then a couple other thoughts, 7.025 sales that exceed the maximum. I assume we're working on regulations to update those. 7.030 products offered for sale. I've heard some comments from the industry. I don't think this is really a legal thing, but that there should be some opportunity to sell other things at cannabis sales facilities to broaden what they are able to offer. So just putting that out there, that I don't think we necessarily need to sell tobacco or nicotine. I don't think that, but perhaps,
chips and soda.
maybe chips and soda, right? Bottled water, those kind of things.
Yeah.
We were just discussing
It's at 7.050. I know someone brought it up before, but the delivery restrictions, especially with the updated purchase limits, I think those should, in my opinion, be revisited. So that it, right now the limitation means you can deliver maybe to 2 customers.
Well, yeah, but how many people order the maximum to be delivered? Is anybody?
I don't,
That worries me.
in my opinion, I would think if you're setting up delivery, you would order the maximum so you don't pay the same delivery fees, right?
Yeah.
Right? In my opinion, that's what I don't buy. But if I was buying, that's what I would.
We are looking at that. We're probably going to increase it to, at least for the next thing, to 10 ounces to match medical for the next one.
I would, not that I have a lot of research on this, but I would propose that it be something that was similar to what was done in distribution, where it was actually a monetary value. Because my understanding is the concern is a safety and security concern, right? And so maybe it be a monetary value. That's what was done in distribution for the long haul trips, right? There was a value set and you had to take extra measures. Perhaps something similar in delivery could be done.
Okay.
I think, actually, that was it for 7.
Great.
All right. Thank you.
David Goldwater again with Inyo. I just want to piggyback on 050 paragraph 4 with Amanda, but take a different angle on it. The definition of private residence, though it's not found in section 7 of the reg, is actually in 1.163. So perhaps I should have come up on that, but it's
okay.
It's the definition. It's referenced. That definition is referenced here. That the definition of private residence, as you have pointed out to me, Kara, excludes weeklies,
Right.
Mobile homes. We get a lot of calls for delivery from people who are in those where our shop is located someplace. It's a more urban, lower income area of town. These are the people that need delivery more than anybody else, yet we're restricted from delivering to them, even though I understand the definition, the policy reason be out of the casino business, but probably maybe find a way to include private residents, weekly mobile home, RV, people that are.
Yeah, and I think that was pulled from references from statutes about private residence, but maybe we could include some exceptions or something like
Yeah, I think it was pulled from some of the taxation definitions. And I think that would help a lot of people. And especially with the proliferation of licenses that we seem to be having. It doesn't seem to make much sense to restrict those people.
Especially when you can go online and find a illicit transport.
That seems to be where they go when they can't get it from a legit.
That's a great recommendation.
All right, thanks.
Hello, Christina Ullman, representing the Chamber of Cannabis. I just want to echo what David said. It's actually quite discriminatory for low-income housing residents, so I think that's a great point. And just changing the verbiage to no casinos would make a lot of sense. So today I am speaking on 7.050 delivery as well. This particular regulation is actually one of the most effective ways that we can increase revenue and profit, which will then start chipping away of the accounts receivable problem that is mounting in the millions and is ultimately the highest form of theft that we have in this industry, people not paying each other.
Right.
So by increasing this to a minimum of 12.5 ounces to mirror SB 277, yes, we will get more revenue out of that. But if we really want to make a significant impact, I encourage us to look to other states. As of right now, California, Oregon, and Colorado all have a $10,000 retail value that they can carry. Now, I know that is a little high, but meeting in the middle at $5,000 would really, really propel revenue and profit. And I think, looking at these regulations, we're not just trying to change stuff to change stuff. Like, what impact can it have so we can have a more viable and sustainable industry? Delivery is probably one of the fastest growing areas, especially since COVID, and particularly for folks with disabilities and seniors or shut-ins. This could affect them. So looking at all those changes, right now, if the average ounce is $125, they can only carry 5. That's $625 they could potentially generate compared to potentially 5,000 or so.
And there was a lot of references to 12.5 ounces. And I'll admit, at first I was very confused, like, where's this number coming from? But then that's because the amount of possession is 2.5 times the original amount. So you're doing 2.5 times 5 ounces. Is that right? Okay.
Yeah.
Just making sure I understood the logic.
Oh yeah. Cannabis math right there.
Yeah. For the paper math.
Yeah. Yes. Thank you.
Yeah, we are looking at changing this again for all the reasons you stated. Yeah. We were really worried because, again, it was during COVID, a lot of these drivers got hit. A lot of these drivers got robbed. So we were
have a
being
number,
very
like,
careful.
a lot is a little subjective.
We could
It was years ago. So yeah, we were getting calls every couple of days for a while.
And COVID, I mean, the height of COVID was 3 years ago. So I think maybe some statistics on like the last year and, where we could find that happy medium. Thank you.
Absolutely.
Never mind.
Hi, again, Abby Kaufman, I guess to close out with the delivery, I think that also, in addition to all of the great points that were already made, I think that adding the delivery flexibility would also, it's like cost and convenience when it comes to the unlicensed market. And so, especially if you're thinking of if you can't get it delivered to your mobile home, well, what if there's somebody right up the street that there's no delivery limits, they can bring it to you there. And so I think that that's just another reason to consider, in addition to making it match SB 277, but even, taking a few notes from other states after analyzing any of the crime stats in those reports. But the other in Regulation 7.030, one thing that I received some feedback on, this is product required. It restricts, says it shall not sell cannabis sales facility shall not sell any food, beverage, or personal care item that does not contain cannabis. And I'm curious as to why. On one side, like, it's an easy way to get additional income, like Home Depot, Office Max, like places like that sell food and drinks. And then on the other side, like, since there aren't dispensaries near the can't be on the strip, right? And then especially in the 110 degree weather, if tourists, after drinking or whatever, and then you're going there, they can't even buy a bottle of water. And I just feel like that's like easy income, if it's prepackaged. I'm sure that, I think that would just be an easy win. I know that was a theme of the roundtable.
And I can kind of go over the history of that a little bit. I won't go into too much detail, but what we were seeing initially back in the medical only days was a lot of these production kitchens were also making uninfused items for sale on, in the dispensaries, and they didn't have licenses from the health department to be a food manufacturer. And so they were basically selling unlicensed food items. And that's where this came from. But I think now that this industry is much more mature, we can work with the local health department and make sure that would they require a permit for these prepackaged items, things like that, or vending machines,
Yeah.
the allowance for that. So we are going to work, Jason and I are going to work with the local health departments and make sure that there's no issues if we add certain language to our regulation.
Okay.
But we think that's totally reasonable.
Yeah, awesome.
Especially if you're gonna get hungry later,
Right, I just feel like especially with the
snacks.
awesome, and I think the word prepackaged would help address the issue that you mentioned. So awesome. I think that was all I had for 7.
There's
Thank
a
you.
language in NAC 446 that does specify windows as a small amount or non-temperature sensitive foods and prepackaged. That exemption.
Okay, what was that? Right.
NAC 446, food establishment.
Awesome, thank you.
Anybody else for regulation 7?
My name is Amber Jansen. I want to talk to you about 7.050. While I'm in agreement that that needs change, obviously with the limits going up, but I do believe that the value should be more of a concern than the actual weight, because that is the concern. And just so you know that I don't really think that the 2.5 is really going to increase sales. So we just did a poll on Talking and Token yesterday. 81% of consumers said that this increase they're not purchasing more. And the 19% that did said it was concentrates.
Okay.
Thank you.
Thanks. Anybody else on regulation 7? Sarah, online, anything for regulation 7?
To provide public comment, dial *9 to raise your hand or click the raise hand icon. Okay, caller with the last 4 numbers 2934, please state your name before providing your comment. Dial *6 to unmute.
Hello, my name is Julia Butler for the record. I did miss Regulation 6. This is pertaining to Regulation 6, specifically to the definition of transfer types. In the guidance that was released in January, it defined transfer types that do not exist or did not exist in metric, and metric still has transfer types such as wholesale transfer subsequent that are not defined in this guidance. And I was wondering if those 2 lists will be communicated together.
We can look into that, but again, I want to be really careful not referencing specifics to metric in case we ever use a different software system or if metric changes their terminology. We just want to make sure that we're not stuck with that. But I'll go through it and see if there's anything that we can adjust.
Absolutely. Thank you very much. And the second question with that, for identical ownership transfer, is identical ownership transfer defined anywhere in the regulations, and how it's different from affiliate?
That I don't know. Steve, you got any? Steve or Dave?
That's something I'd have to look into. You're talking about metric transfers for identical owners versus affiliate transfers, correct?
Yeah.
Correct.
I'd have to look into that.
Yeah, those are tax selections, I believe. So we'll
I think
look into it.
Yeah, I think that might be in the Department of Taxation's regulations, but if not, I'll look for it and see if there's something we can clarify on our end.
That would be greatly helpful. I did go look through the NRS 372A to go look for that definition. I couldn't find it. But if it is in there, please, more guidance on that would be incredibly helpful.
Okay, great.
Yeah,
Thank you very much.
Out their NACs are updated at this point either.
Right.
Any other comments, Sarah?
There is no additional comment.
All right, let's move on to regulation 8. Anybody down in Las Vegas have a comment on regulation 8? Quickly. Sarah, online, any comment on regulation 8?
There's no online comment.
All right, let's move on to regulation 9. Any comment down here in Las Vegas on regulation 9? Always got to be one.
Great. Okay.
So for 9.040, and this might also, it'll probably tie into the labeling. But there was a desire expressed by our committee members to readopt a portion of the previous regulation in NAC 453A.508 about including expiration dates for flower too, and having a flower have an expiration date of 1 year from the date of harvest. I think that this has come up in a few like public comments, but that was, there was some suggested language, but I know that will impact 12, but it also applies here. Is that something that you all have considered?
Yeah, we've received some complaints from consumers that their cannabis was expired or that it was so old. So that's something that was on our radar.
Okay,
thank you.
Thank you.
Thanks. Anybody else on Regulation 9? Sarah, online, anything on Regulation 9?
There is no online comment.
Let's move on to Regulation 10. Any comments Senator Las Vegas on Regulation 10? Sarah, any comment on Regulation 10 online?
No online comment.
Nope.
I'm back.
Yeah.
You're gonna find
Trying
out
to slip by.
I'm a bit of a renaissance over here. So, just with the independent lab testing, I'm not sure where the stipulations came up on what specifically classified something as being passing and or. I've recently found out that a lot of people aren't really educated on a COA and or what microbials are.
Right.
One thing that I have gotten an issue with is called aspergillus. If you're not sure on what aspergillus is, you're breathing it right now. It is literally everywhere. You go home, it's in your house, it's on your clothes, it's on your pets, it's everywhere. In the entire world, there's only about 200,000 people affected by aspergillus. And those are specifically people that have lung cancer and severely depreciated autoimmune systems, such as my niece with leukemia. Would not be good for her. Currently, I've been in cultivation now for quite some time. I actually have a degree in agriculture and botany. So I have an idea of what I'm talking about. This is not the first plant that I've played with. With the labeling, with a high amount of tests failing for aspergillus, it's almost encouraged businesses to get these radiation machines, and they're not waiting to fail a test to use them. They're using them before the labs get tested.
Right.
So kind of goes into the radiation thing. Internationally, fruits, vegetables, meats, if irradiated, have an international marking. This isn't just for the state. This isn't just for this country. Internationally, there is a marking. Having that marking on there lets the customer know, just part of consumer awareness. I almost feel like we're the bad guys in the 80s car dealership days, okay? Because our consumers have no idea what their products are. Now, with these treatments, yeah, they're gonna kill off your microbials, but if there was an actual physical piece of yeast and or mold in that product, these radiation machines, Willow treatments, whatever the machine is still going to allow that product to pass. Let me give you the example that I gave the owners that I work for. So fruits, vegetables, meats all get irradiated. But you're not gonna buy a moldy orange in the grocery store. You're not gonna buy green meat. That store can't sell that to you. But currently, with the way things are worded and the way things have been starting to roll, is you can still buy moldy wheat. You can still open up a jar and find a big white piece of fluffy yeasty mold in there because these machines are allowing bad product. If somebody's failing consistently for yeast and mold, it goes back to, it's a policy and procedure issue. It's an SOP issue. They're not clean. They need to clean up their business. What I am suggesting to discourage people from using radiation treatments is allowing aspergillus Putting a note on that label, this may test positive for aspergillus. Peanut butter kills people every day. We still sell it in the grocery store. I'm just asking that we get away from encouraging these companies to do bad business and not have clean product. With these radiation treatments, there's no encouragement for them to do anything better. It's just putting a Band-Aid on the problem. And that would be the end of my comments for today.
Thanks. I do just want to clarify one thing with aspergillus. Yes, it is ubiquitous. It's in the air. It's everywhere. However, we're only testing for the 4 pathogenic species that are commonly found in cannabis.
Right.
That can cause very severe health effects. They can be, you know, just irritants for healthy people, but some people might not know that they're immunocompromised. A lot of people find out the hard way that they're immunocompromised. And because this is still a medical community, we're very focused on protecting those medical patients. So I do just want to put that out there that we take aspergillus.
Oh, no, that's just it, is I strongly support the labs. I want to know that there's not pesticides,
right?
That there's nothing. I
I
appreciate
understand.
that whole factor. I've been in it since the beginning. I appreciate knowing that what I get is not the same thing that was around 20 years ago, where God knows where it was before you got a hold of it. I appreciate the labs doing their job, and I appreciate being in a clean facility. I know the facilities that I have run are immaculate, because I get told so by the CCB during my inspections. My last score was 99%. Yeah, so this is why I empathize with, that's why I do want it still marked on there for those medical patients that are aware, but it goes into that whole cost onto a business and the long-term effects of it's really creating this vicious cycle of where I'm seeing just a lot of bad product put out there in places that are adhering to good policy and procedure and correct SOPs.
Right.
Are losing out because they don't have $500,000 to buy a radiation machine.
Right.
They're a small grow facility with 4 rooms. They don't have that. So it's not leveling out the playing field as much as we would like to in that retrospect.
Thank you.
I'll discuss this right because it ties into, I'm sure some people here want to talk about 12.065 again, and when we get to Reg 12. Again, Reg 12 is where it is ordered that we label the cannabis with the Verdura symbol. However, that got put on hold almost immediately after we approved the regs. Because again, there was a lawsuit that we had with one of the radiation machines that was having problems with it, of course. We went through the process, a lot of you here know, we went through workshop after workshop, discussed this in and out, created a very, very tame version of a line to put on a label. And the board adopted, the board approved it. We were going to move it into regs. It got pulled. If you're familiar with our old regulation process in this, the Ledge Commission has 2 weeks to pull it. All right. They pulled that one. They looked at it. They said we weren't allowed going forward with it. And we're still in the process of adjusting the reg based on that process. Hopefully it gets cleaned up when the NACs are out.
Just to give you a point, I work in a cultivation. With the way metric is set up, I'm not even capable of marking my flower as being remediated.
Right.
Yes.
I know.
So even when trying to do the right thing, you can't. So just let you know, there are some concerned people that would prefer to give the consumer a better product that doesn't have mold in it.
We understand.
I appreciate it.
Thank you.
Again, take a look at it again when the NECs come out, and then potentially maybe look at another petition process if you're unhappy with the results.
Yeah, that's how I got involved.
Hello. I'm Nicole Buffong for the record. I represent the Chamber of Cannabis and Minorities for Medical Marijuana. And a fellow conscious consumer and member of the Chamber, Jason Brenninger, certified surgical technologist with more than 30 years of direct patient care, who's the owner of Atlas Alchemy, couldn't be here today, but he did submit a written comment, which studies the cannabis plant and how the human body responds to it. Explained to me that the concern is not the radiation, it is the fact that the CCB is allowing this remediated flower to be put on shelves for consumers to use. We should not have moldy flower on the shelves in Nevada. The issue to really look at is why we are testing in the first place. The reason for the testing is so we are not smoking mold. This is a safety issue, and the reason for the test and the expense to remediate after failing for mold or to irradiate prophylactically defeats the purpose of the rule existing in the first place, which is the safety issue. Allowing the sale of mold, though dead, in the biomass, it is still present, which is then being sold to the public, and we get to smoke those proteins in dead cells. The other important issue is to look into the true safety issue and actual numbers from exposure to molds in cannabis and the effects. What does the empirical data have to say? That is the place for this discussion, where decisions that affect our health are science-based on actual data to establish true risk and testing needs. Nevada should be celebrating those cultivators that never have to remediate their flower and creating an industry standard for SOPs, ensuring that our medicine is grown in clean facilities that do not require radiation on finished product. I spoke with Speaker Yeager, and he explained to me that CCB told legislators during the Legislative Commission meeting in December of 2022 that the warnings did not need to be put on the label because it could be found in the soil report.
Oh, I can clarify that.
Okay, great.
That was a recommendation from the people who were not in favor of 12.065 labeling requirement. They
Right.
said, why don't you just put it on the soil amendment report?
Okay.
We explained that no one knows what a soil amendment report
Or how to
is.
find it.
Or how to find it.
That's right.
Or to even ask for it.
Yeah,
And that it wasn't an appropriate place for it because you're not amending the soil.
that's right.
You're
You're
amending the
radiating the
plant,
finished
yeah.
product. Yeah.
And so that was the recommendation, not from us, but from people who utilize this.
Who, I guess that's what was brought to that Legislative Commission. Okay.
Not,
And
not by,
from us.
not by the CCB.
Okay, okay, and thank you for clarifying. But I would like to propose to the CCB that a workshop is created to discuss. I know we're not on 12 yet, but if the regulation is there, like you said, you're working through enforcing it, then I don't understand. It's not in the soil report. And so where can people find this information? Where can consumers find this information besides somebody like me, who's an industry individual insider that knows who's using radiation remediation and who doesn't? Because I know the people and the growers, but that is not public knowledge. And so what if the regulation is there and other regulations are being enforced, why isn't this one being enforced?
It was put on hold by the board.
It was put on hold
um,
because of other influences that do not want this on the labels.
Okay, I understand that. I understand that they've spent thousands and thousands of dollars on these very expensive machines to be able to use it on the product that they're selling because they are about profits and not people. But my concern is if they are in this industry and they have a license and they're not following the regulations of the board that requires them to follow the rules and regulations, then why are they being allowed to like skip this?
They're allowed because that is not an enforced reg right now. That is put on hold by the board because of what happened back in 2020 even? It might have been 2020 when it got put on hold right away.
And then the legislation didn't approve our new language, so
Yeah.
it's still on hold.
Okay.
And I'm hoping it gets corrected with, we're working on it. It's the best thing, clearest thing I can say, we're working on it. We, again, the proposed language that we had, agree with you, it put it on the label, it allowed people to know that a product was remediated. We weren't allowed putting that on the label, so that's all it is right now. We're working on it.
Okay, well, since we know that there are cultivators in the state that don't fail, that don't use remediation because they have clean cultivations that don't require them to have to radiate the flower, is there, what would be the process to recommend to the CCB and the state that there are SOPs that are put in place in cultivations and grows that would make sure that everybody's kind of following a standard to enforce a clean facility?
I will say, I know nothing, and I know Kara and the inspectors, every time they go into a facility, they give them recommendations on how to grow cleanly.
Okay.
Literally every single time they go in there.
There are
So-
certain things that are violations. So if you read through all the regs in their entirety, personal hygiene is in there, sanitation of equipment and utensils and floors, walls, ceilings, that's all in there. The maintenance of the building, that's all in there, and that's all to prevent contamination of the product, right? And we do look at the facility's SOPs to ensure that they're operating in a manner that's not going to lead to contamination. However, sometimes they choose not to follow these, or they overwater, or they do something that encourages microbial growth that is outside of, you know, your maintenance stuff that we would normally handle. Or something happens, there's a leak, there's a flood, there's things happen. So we understand that. We do go out to the facilities at least once a year for inspection and at least once a year for audit. We look for any signs of, non-smooth, easily cleanable surfaces, porous materials, things that could encourage these failures. And we do address them with the facility. It's on their statement of deficiencies. They're penalized for it, potentially maybe getting a civil penalty even. But for whatever reason, some facilities still choose to do things the way that they're doing things and have pest infestations or mold or whatever you might see. So.
Okay. So thank you for the clarification on that. I will get that information back to Speaker Yeager. And so I'm hoping that I know where I won't be able to stay for Reg 12. And so I've made my comment about 12.065. I feel like they should be following the rules. There should be some type of label, or if it's a symbol that's put onto the product, just so the consumer knows. I'm not here to debate whether or not radiating flour is good or not good. I just know that as a consumer, conscious consumer, I don't want to smoke remediated flour or any products that have been remediated. And so I just choose wisely when I'm choosing what products to consume and buy in the regulated market based on what I know as an industry insider. And I think it's just fair that everybody should have that same information.
Agreed.
Don't disagree at all. It is. Again, we're just in a rough situation right now. If the NACs come out the way the Ledge Commission ordered this reg to work out, it will order that any remediation is to be listed in the soils amendments.
And then
but if that comes out in the NAC, then you have the ability to petition or come to us at one of these meetings again and talk about it once again, and then we can start the process again, because this was a 3-year-long process we took to try to get this.
That's why I went to Speaker Yeager.
Yeah,
that's why I went to him to get more clarification and understanding of what this process looks like. He explained to me that another workshop is going to have to be brought forth on 12.065 in order for it to be amended or for it to be reversed or anything to happen in regards of that. And so one real quick question. So what is the timeline on this pause, like this hold for
NAC? We have no idea. Honestly, I don't think it's been done in the state where they've taken a complete set of regs and turned it into NAC after the fact. So
it's a backwards process from what we normally see.
I wish I could give you a timeline. I do not know.
Okay, thank you. Appreciate it.
That's a question. Can I ask from here?
Sure. Well, actually, please come up so we can at least get it on the, yeah.
Dina Felice with Chamber of Cannabis. So I met with the radiation machine people back in 2021. So I got one approved for the facility that I was working at the time. They were saying the machine is actually pre-approved by the CCB. So I would assume, CCB is going to put like regulation in place where requiring facilities that use that to put some sort of, on the label. Is the machine still pre-approved by the CCB?
So
writing?
We pre-approve all equipment. You would have to ask the facility for that in writing if they've had it approved. But we pre-approve all equipment that touches cannabis. So anyone who has this remediation equipment has had it approved by the CCB.
Okay.
Some of it, I won't go into why some of it was approved, but
you still have to put in application for equipment request.
Yeah.
Okay.
You do.
All right. Thank you.
Mm-hmm.
Nice crown. David Goldwater. I'm going in reverse this time. I'm going to go to the definition before the regulation. In 15.080 paragraph 3, in the regulations, it references wasting out cannabis for the.
I mean, 10.0 is it?
Correct.
Oh, you said 15.
Yeah, no, 15.0803 references disposing of cannabis.
In
the
accordance
same-
with 10.080.
That is correct. I'm not, and I don't have a specific suggestion here. I'm trying to map out in my mind how this works best. And it may require a little fine tuning to how we're wasting out cannabis, how we're wasting it out in the lounges. Currently, we all have SOPs on how we do it, and we enter it into metric, and it all balances, it all works out great. And it's actually unopened cannabis that's wasted out. In the lounge case, we're talking about, I don't know, just for the case of metaphors, things that are in ashtrays, things that have been eaten, and
Ketchup.
we're asking our employees now to go through that exact same waste disposal system that isn't quite, it's not seamless. So if you read the reg, you kind of go over it and you go, oh, we'll just shove it in and shove it in some dirt and let it go. And anybody that's working in a facility knows that's not the case.
Right.
So if there is if I'm reading it wrong, obviously nobody has practiced this one yet and you
Right.
haven't inspected on it yet. But if there is a way to kind of fine tune that ahead of time, so it's not as it's working in my mind where the lounge employees are taking the unused cannabis, weighing it, subtracting it from what was sold,
Yeah.
coming up with that math. Okay, you know where I'm.
No, yeah, and
We've been
and
thinking about this.
Okay.
yeah, we've been talking about it. If you're planning on opening anytime soon, I would recommend reaching out to Keoki Allen or Jason Vinales, who's not there when I point at him. And or myself, and I can work with them and we can get you some guidance. But it sounds like what you're looking for is more of like a overall guidance document for lounges, maybe, or
Yes, sir. I'm sure you will have some guidance documents and I'm sure in practice it'll be fine. I guess the reason I'm here now is that requirement to waste out is in 10.0803. And if that needs some modification or fine tuning to accommodate what practice will end up being there, that's
Probably.
all I'm asking. And like I said, I apologize for having no specific recommendations, but perhaps it's something we can all workshop on.
Yeah, thank you.
Thanks.
And no, we're not gonna make you scrape the ketchup off the burger or weigh the ketchup before throwing it away. That helps.
But that sounds like so much fun.
Yeah, that would be a full-time job.
No, we're gonna make it mandatory.
I have
Required.
extra time. Amanda Connor, for the record, going off David's comments on 10.080 regarding cannabis waste, subsection 3. It specifically says that waste containing cannabis must be rendered unusable by grinding. There's no exception if it's cannabis liquid or anything else. Everything has to be ground, or if it's already ground because it was made for pre-rolls.
Does this say or approved or another method approved by the board later?
It does say, that's in subsection A. So I have had, and the clients request not to grind, and certain inspectors have denied it, saying that's not you can't get out of that. Only the mixing is another method approved by the board. So I would recommend either we say unusable by grinding if not already ground or liquids, in a liquid state. Or we can say, unusable by grinding unless, approved by the board or something like that, right? I have seen where clients, some of my clients have been told they have to take their liquid oil and put it in a blender, grind it before they mix it.
If that ever happens, email me, please.
Yeah. So just putting that out there. So similarly, I know the lounge we've been working through, and you're not going to require scraping the ketchup off the burger to waste it. My understanding is they have worked through a process that will allow kind of end of day destruction and some adjustments on how that's done in metric, because we're dealing with product already sold to customers. I think we might need either guidance or some regulation updates. I know that's 15, but just putting that out there.
Definitely be guidance first.
Yeah, I was gonna say, I think guidance in the meantime and then reg changes.
The metric issue is really a big one.
Yeah.
Reconciling that, weighing what's in and out.
Yeah.
Metric is fun, is what everyone tells me.
I know. I'm very appreciative of Kyoki and all her work because then I don't have to do it.
Anybody else on Reg 10?
For the record, Timothy Eliotto speaking, and I believe this is still on relation number 10 still.
Yep.
I just wanted to include that there's unfortunately quite a bit of misconception in the industry on how the laboratory operates. And speaking from experience, I worked for, I'm not sure if I could disclose, Cannabis Labs right from the very beginning when it was a startup before they opened their doors. I was one of the, I guess, early participants that helped the cultivators in terms of consultant. There are so many issues that we face even before ISO 17025 was even put in place in terms of and still there isn't a standard for testing. So I do understand there is a long, we have a very shaky road that we're traveling. One of the issues that has been brought in the industry is potency testing, which has always been an issue, which for some reason, we have to understand one thing about the labs. Unfortunately, for the laboratory industry, within the cannabis industry, they are at the limit in which they operate in. They are taking a huge, financial, I guess, setback. The difference between the pharmaceutical industry and the cannabis industry is that even with the same instruments, whether it's HPLC or MSGS, your in terms of your revenue, your return in revenue, in comparison to the pharmaceutical industries, that's what the lab techs are used to. Then the cannabis industry, it is light and day, right? If you're doing a full panel testing on cannabis, you're looking at what averagely 400 to 600. I'm not sure what it is these days, or what they're paying out these days. But then you're looking at it in comparison to the pharmaceutical industry, that's like $45,000. So the labs, they're used to coming from an industry in which they did almost, if not little, as the same, duties or job in which they were able to generate much more revenue. What I'm saying is that if we keep restricting the revenue in which these labs are, generating, who suffers? The consumers. Okay. Cultivators are always going to shop. They're always going to look for, which lab. I'm not going to go there. Okay. Cultivators have their own, we're in all industry insiders. We know there's a lot of people that could just come here. Oh, we never test a feel on microbials. No, let's be honest. And even those that are saying that, what level of expertise do you have? How can you walk into a 400,000 square foot facility room and then determine which is prone to like aspergillus, growth? Some of us do, right? So when there's a difference when you're speaking from experience and then when you're just relaying or conveying messages that you just heard. Okay. So we take this industry very serious because this industry is our heart. We put our life, and I mean, we put our life on the line. We got raided at some point. Some of us, we know exactly what it feels like to have the, semi-automatic weapons at your face, and all you did was, I'm not even going to go there, but we have been traumatized. We have had to stand and fight to get to where we are right now. Watching the industry decline in terms of quality and sales, We bear that responsibility to turn that around. We can't keep turning, pointing faces at the black market. The black market is not the problem. The black market only thrives, legacy market only thrives because you are failing. And I'm not necessarily saying you. I'm talking about the cultivators are failing. And well, it takes someone with that sort of level of experience to say that. I could bring in all your top-notch cultivators, okay? Let's sit down. We some of us got work too. You may not know, none of you may not know that about me, but if you look into what I do, you will know what I bring to the table, okay? So if we have been able to accomplish certain things, and then we're noticing the decline in which something we have done not being able to be upheld by those that are given the opportunity, we're like, guess what? We can do better. And we did. When we were given that opportunity, or when we were operating, we didn't have these issues. We didn't have sales constantly declining. You know why sales are constantly declining? Besides all the usual suspects, genetics. Who talks about these genetics? So what is the business model these days? You have a facility who has a business model who wants to say that I want quantity over quality. 600,000 square foot facility. I just want to have, a white label for 7 or 8 California brands. That is their business model these days. So what do? You have enough space for cultivation, enough space for production, and all you're doing is white labeling brands. This is your business model. You hire through an agency, $12 to $15 an hour. You recommend that these employees, it's better if they don't even have any expertise in the cannabis industry. This is the reality.
I hate to interrupt. I love where you're going with this, but do you have any specific comments on what we can change in Reg 10?
Okay, I'm sorry. So with the lab, let's focus on stricter mycotoxins regulations first. Stricter mycotoxins regulations. We've heard about aspergillus. Yes, there are specific for colonies that we do test for. I believe Niger, Flavis. It doesn't matter. Within other states, they have moved forward to, implement. I believe we're still going under the BCC regulations here. Still, have we changed our
The NCCRs?
No, the BCC, which we adopted from Cali, or are we still going through the AHP?
We adopted regs from Cali.
Oh no, we at some point we adopted the BCC. I mean, you could look into it later. But all I'm saying is that let's look into mycotoxins. Let's make stricter regulations just so that
Mycotoxins.
Yeah, we do. But you see, the cultivators of cultivation facilities, they're bypassing it. That's the reason why we're talking about radiation. First, clarify in the beginning, we had the terminology was quarantine. So what difference between quarantine and radiation, right? So we went from quarantine, because I was there in the beginning. The reason why I began to quarantine this process was what? They failed their microbial testing or aspergillus or whatever, right? So then they called the chemist, what is the best way to remediate this, right? Oh, the quarantine process. Eventually that became a habit. That is a bad habit that the cultivators picked up. That's all I'm saying. And to be able to save this industry, we have to reverse that bad habit. So it used to be a comfort thing where you could just call the chemist and have them remediate or quarantine that product. Then eventually they adopted that into their business model. So now they're like, hey, there's no need for expert cultivators any longer. We have a business model in place. We already know we're going to fail. We have our machines that is going to radiate it. So guess what? This is our business model. But the issue with that is you cannot force consumers to consume.
Okay.
Thanks. You. Anybody else have any comments on Regulation 10? Online, any comments on Regulation 10? You have?
There's no
Sarah?
online comments.
All right.
There's
Let's move
no
on to
online.
regulation. Let's move on to regulation 11. Any comments on regulation 11? How you doing?
Good. Good afternoon. I'm Bruce Burnett, representing ACE Analytical Laboratory, and look forward to the March meeting, continuation from the September issues that were raised before.
Absolutely.
Adam Fulton represented all the laboratories at that September 23 meeting. And I don't know if I should, but I can, because we didn't know, resubmit. Do you want to resubmit it? You have his letter? Okay.
We're using it.
Just so it's in there in the record for this one. Because it contains a lot of things. It didn't speak to 1.125 because that integrally ties into everything is involved in regulation 11. I assume will come up, and you mentioned the BOTEC analysis paper already addressing statistical validity and the analysis necessary for that. I just have two things that I would like to request at this meeting that I think fall within 11, and that is I'd respectfully request that the CCB implement the database that was required by the state legislature, or NRS 78. I just have to say it's 678B.635. And I would also request that, I know it's a may, but I wish it would be a shall, put the RLAX back in place under 11.085. That was part of NRS 678B.540.
Got it.
That's it.
All
And we'll see you in March.
Sounds good.
Look forward to it.
Okay, and you already have that. So
You'll get
that's
the
part of it.
response back from us soon.
Okay,
So,
yeah.
yeah.
Thank you.
Great.
Thanks.
Thanks, Bruce.
I promise I'll only come like one more time.
I don't believe you.
Actually, I think that's actually true. I never lie to our regulars. Like, honestly, sorry, that's a bad joke. Okay, Abby Hoffman for the record. So for regulation 11, I just wanted to call out one of our members' statement who Nicole also mentioned, but Jason Greininger from Atlas Alchemy submitted a written comment in advance. So I just want to verbally state that for the record to encourage his points to be considered. And then I personally just have some questions about, it says, prescribe to the board an electronic copy of the certificate of analysis for all tests. And sorry, I'm talking about 11.070 in subsection 9. And then in subsection 13, it also says the board may publish on their website all certificates of analysis. And with all of the packaging, labeling workshops, just having access to that, I feel like would be really, really helpful.
It's almost done.
Okay, that's what I thought. And so in alignment with that, and then maybe I won't come up again, is like in alignment with the desire to minimize packaging and ensure consumer safety. Like if there could be some guidance on the approved electronic medium that's in regulation 12 for scanning. In regulation 12, it says if it's on the label or that, but like what if it all went to that new online database and then it's like addressing the packaging?
It's not going to work like
Not that type
that.
of thing.
So the database is going to have access it's front facing. It'll be on our website where you'll have access to all of our lab results for anything that's out on the market. That's all it's going to have there. So you could compare it to the label. If they want to, we don't want to hold them to just one specific like electronic medium for the label.
Right.
Because, you know, some people might want to use a QR code. Some people might want to email it, text it, whatever.
Right.
So we want to leave it open for the industry to tell us what they want to use.
Okay.
And then we would review it and let them know that it's acceptable.
And okay, that's helpful. And in the, like, since the COA is like, what is in the building out of this online thing, is it structured in a way, and this might be too like technical, but for whatever virtual guidance that's approved or for the virtual electronic medium, like, is there any way for them to talk to one another? Could there be?
Yeah, there could, maybe, yeah.
Just
We can look into that.
QR code and link in is what you're thinking? Or-
Yeah.
Link to the lab COA in the labeled electronic medium.
And then it's all out there. It's the same information. It's consistent, and it's kind of two birds and potentially. And I think Jason might expand on that, but that was all for me, I believe, except one thing that I just wanted to put on the record is for 11.085. It's just kind of odd to me that these are random, but then no matter if they pass or fail, the cultivation facility or production facility is responsible for all costs for these random tests. And I'm not in that role, but just in reading through it, it just seems a little bit odd, especially since there's no guardrails for how often those random compliance checks, just in reading it, they could get hit every day and then just have to pay every day.
Gotcha.
I know that's not what's happening, but it just is, seems a little illogical and could be abused. So I just wanted to put that out there, and that will be the last thing I say. So,
Thank you, Abby.
Thanks.
Amanda Connor, for the record, I do believe we are working on testing regulations, so I'm not going to jump into a lot of things. But one thing I don't think that's been brought up that is an issue that presented itself in the last year is 11.065 regarding use of approved pesticides. And basically, if there is not, or if an unapproved pesticide is found to be used, there's not an ability to test for it to give consumers or the CCB or anyone information on if it actually did appear on the end product that went to consumers, if so, what quantity. I would suggest that mistakes are gonna happen. And for public safety, it might be nice to have the ability to test if that's discovered.
And I've got mistakes that happen, but is there any reason why a cultivation facility should have an unapproved pesticide on site?
No, but mistakes are made, like Amanda said. And I think the problem that we run into is, one, we'd be asking the labs to be capable of testing for all these different pesticides. And, you can't just throw something in a bucket and say, what's in it? I wish lab testing worked like that.
I get that, but I do think that there is a potential that, and a way to write it, that it says, if a lab, is willing to test for it, because they may be willing to charge the person who did it, right? Not saying we mandate that labs have the ability to test for everything that may ever come forward, but also to have that information may be helpful, right? And if there was the ability or willingness to test for it, simply because it's not in regulation, not being able to do it would be,
Yeah, and I think you could do that through an R&D request. You can do additional testing or limited testing through an R&D request, but I think the reason that certain situations, it wouldn't apply to every situation, and just having a negative result wouldn't necessarily tell you it's safe, because sometimes they're like household use pesticides. And so it's not the pesticide chemical that's dangerous, it's all those.
No, I completely
chemicals.
agree. And I'm not saying it
Okay.
mitigates completely and would
Okay.
render the product safe. I'm saying more from a public safety health knowledge. I know that there were, in the issues that happened, there were questions on, what was the potency? How is it still on the product? Those kind of things, right? I'm not saying, again, I'm not saying we should test for everything, but having that ability, if we could have the knowledge, sometimes just having the knowledge, even if it doesn't fix everything, is helpful.
Understood. Thanks, Amanda.
Thanks, for sure.
Got a really quick question here. And also our suggestion, this question is there a serialization components to the COA that is going to be technology that's, I guess, that is going to be, I guess, the database for our COAs?
I think that, I'm not sure exactly how that front-facing site is going to look, how you look it up, but I think that the metric tag number or the lot number, production run number, any of that information should get you to the lab result you're looking for.
Because the reason I ask is in regards to FDA's regulations when it comes to recalls, right? I guess one of the biggest issues we've had in the cannabis industry in pertaining to recalls, there isn't still that human element where if there is, a defective product, within, you know, a specific time frame, we have that human element in place where we could take it off of the, you know, the market, right? So, and not having that serialization components, like in comparison to the pharmaceutical industry, which they could afford that serialization. I get that, but maybe the cannabis industry, we still are very, you know, infant. So we may not be able to afford that serialization component to it maybe as of yet, but as a consideration, to be able to help, spot if there's some sort of recall issues, that we could be able to basically spot it and then get it out of the market within, you know, a timely manner, and then have a human element to it as well.
Yeah, that's great. Yeah, that's what we're currently doing. So we use the metric tag number, the production run number, or the lot number, or whatever we have available, and we use that to trace all the packages back. And we can use metric to place administrative holds on product. We also reach out to the facilities, let them know this is on administrative hold, you cannot sell it or transfer it. So that is basically in line with what our current processes are. I appreciate that.
Thank you.
Thank you.
Any other comment on regulation 11? Go.
Sarah Adams from Planet 13. I have a background in accounting and legal, not lab stuff. So I just wanted to give you, if I can, an email from our VP of Operations, Chris Wren. He has a concern about the fact that, I don't want to say this wrong, but in Nevada, we test based on like wet weight instead of dry weight. And so, so the potency of our flower is can be viewed to be lower than that of just California, for example, which tests on dry weight. And so I don't have a full understanding of this problem, but if I can, I just have 3 copies of this email. I think it probably well explains a problem. But then I did have something a little simpler that I may have the ability to explain to you. So testing of infused pre-rolls, just generally, infused pre-rolls, I guess, are tested as flower. And so the potency is displayed on the COA as a percentage. And the problem is that the percentage of THC is out of the total weight of the pre-roll. And if it is like a blunt, then, you know, part of the total weight is going to be the blunt wrapper, which can, blunt wrappers are pretty thick. That can make up a significant portion of the total weight. And so just that, I think that alone kind of skews. It's not like the wrappers have, well, maybe some of them do, but our wrappers don't have cannabis in them, you know?
Right.
And so I think the way the lab tests these things is they just grind it all up to make it as homogeneous as possible, and then they do their test. But to be required to include the wrapper in the test kind of just gives you a skewed, you know, percentage of the total weight of the package of as far as like THC potency goes. And further, just say you have, you know, 2 different strains, which one of them is like fluffier than the other, or one is less dense than the other, then I may need to use more blunt paper, you know, to even though this particular product, super blunts, they all have the same amount of flour, but that same amount of flour may take up more room because it's more or less dense. And so that's going to exacerbate the problem of the blunt being like too high of a percentage of the total weight. And so that further is just messing up the THC potency.
Okay.
And so one sort of not solution, but kind of partially there is we do have the ability to ask the lab to give us the THC per unit instead of as a percentage. But again, they would be basing that on that faulty percentage that I just described. So, I mean, I would prefer to just take a number from the lab rather than having to do some sort of math to convert, you know, percentage THC for this unit to the number of milligrams of THC, which is required to be on the label for all production items. But again, it's based on based on a, you know, skewed percentage. And so we propose that maybe infused pre-rolls should just be considered to be enhanced flower and be subject to the same package requirements as flower. And so maybe they shouldn't have a milligram limit, just like flower doesn't have a, sorry, THC milligram limit, just like flower doesn't have a THC milligram limit.
Okay.
So
Look at it.
And if there's another solution, I mean, totally, we don't have one, unfortunately, but just the way it's being done now is not, we're not like giving people accurate results, really, I don't think. So, okay, and then on another note, kind of back to what I was saying on, you know, metric functionality and stuff being available for everybody to see while it's being enforced. There is, so regulation 11.075, which covers retesting. There's like internal policy that says, you know, if your batch fails for XYZ, then it's not eligible to be retested. But that is not written anywhere that I'm aware of. And I did reach out to CCB just to ask, you have a list of things which would, you know, make something ineligible for retesting? And the answer was no, there isn't a list. It's just kind of case by case. It seems, I don't know, it seems like things shouldn't be case by case. I mean, you do have, just for example, I think heavy metals, that actually is something that you don't allow to be retested for. So, I mean, you have a list in a sense, but, you know, it's, I may just not know exactly what's, or the industry may not know exactly what's on that list.
Yeah, so we have a list we actually just created and I just showed to the executive team. Yeah, or not created, but created for public viewing, for sending to extraction or remediation after failure. And so we can add retesting to that as well.
Okay, cool. And then as a broad concept, I wanted to suggest or just bring up, because my background is in accounting, I'm just aware that take the Internal Revenue Code, for example, our tax code, that's the actual statute, right? And then the Internal Revenue Manual is, it's a manual which the public has access to, but it's really meant for the revenue agents to be able to just consult to help them know how to do their jobs, basically. And so it is extremely extensive, and I'm not suggesting that you create like several thousand-page document on every single thing that you do, but for things that are directly affecting, you know, what operators are supposed to be doing on a day-to-day, such, or, you know, just with the retesting thing that I just mentioned might be a good example of that. If there are some rules that we are supposed to follow or some guidelines that CCB agents are following when they make a determination on a request that I've made, like whether it's a retest request or if it's, I mean, anything else, facility modification request, if there are some guidelines that agents are looking at to make their determination, I really think it would be super helpful if that could be made available to the industry in the form of a manual or just, you know, additional guidance being put on the website or something. If I could, you know, before I take the time to make a request, it would be nice if I would know ahead of time, this probably isn't going to be granted, so there's no point in spending time on it, you know? So just,
we should have it up soon.
Oh, okay, for other stuff too, or?
For the request to send to extraction or request for remediation, and then we can add requests for retesting, and then we can add some other stuff on there too. But yeah, that's an easy ask. We do have internal guidance, so it's not hard to communicate that to the industry.
Okay, and I would also ask that things like, you know, guidelines that, I know there is an inspection like checklist, which is made available on the website, but if there is any additional guidance provided to agents, just that they're supposed to be following when they're doing inspections, then I mean, or audits, documentation audits or something like that, I think that would be super helpful to be made available to the public as well.
Yeah, and something that the Southern Nevada Health District and other health departments have is like a violation standards document. And it is like thousands of pages, but you can go to a specific regulation and say, here's several examples of what happens. We've been working on something like that since I started. It is ever changing and never complete, but that is something that we would like to get out to industry. We just don't really have the manpower to do that right now. So. But I know exactly what you're talking about.
Sorry for taking away.
No, you're
time
fine.
and effort.
Yeah.
Okay, I think that's all.
All right, thanks.
Thanks.
Sarah.
Anybody else on Reg 11?
Hello, everyone. Katrice Saunders for the record. So in regards to like the testing and labeling, I feel like it's imperative that the remediation for radiation go on the labeling and packaging. As a consumer, as a patient for a long time in the industry, I am more likely to go to a legacy operator because I know they're not using radiation. I feel more safer that I'm not going to get sick from medicine that has mold and has been remediated and quarantined just because people are trying to make their mark for their margins and not caring about people's health and safety. That needs to be the forefront. And the fact that it was written and then taken out is kind of criminal, and the people that put it on hold should be held accountable because they're putting public safety at risk. Thank you for your time.
Anybody else on Reg 11? 11, yes.
I know, we're all getting.
She wakes up at the back. Online, anything for Reg 11?
There is no online comment.
All right, Reg 12, any comments on Reg 12?
Good afternoon, Amanda Connor for the record. I believe that there's regs coming out about packaging and labeling and
That's fine. Yep.
12.
all of 12. So I'm not going to get into a lot. The one thing I would comment is in light of the legislative change increasing the transaction limits, I would propose that 12.010 may want to be reevaluated on maximum single package serving size, at least for certain products, such as the more than 1 ounce of usable cannabis.
Okay.
Separately, I brought this up at the workshop regarding packaging, but in that same thing, since sales facilities are now able to sell to lounges, I would propose that we put an exemption if they're going to be selling bulk for the lounge to then use.
That's fair.
Otherwise, I look forward to those regulations.
Okay. I know you do.
Oh, yeah.
Associate my comments, David Goldwater, with Danielle, associate my comments with Amanda. And I look forward to those regulations, but I sure want to say that 12015 is particularly on paragraph 2, the second sentence there is one of the worst written sentences I've ever seen. I have no idea. I tried to jam it on, but everybody wants to live up to the spirit of good packaging.
Okay. We will revise that. That's funny.
Anybody else on Reg 12? And again, if you're missing out, we're going to have a workshop next month on almost primarily Reg 12. So,
Hello, Sarah Adams from Planet 13. I'm sorry to harp on this, but going back to 12.065, so you had mentioned that probably in the process of NCCR over to NAC, the new version of this reg will include that, or, you know, sort of remediation notice be put on the soil and, but why would that be the case? Why would that be the version which is going to appear in the first run of the NACs, I guess?
That is what was proposed.
that was what was approved by the Ledge Commission at
So
the
that's
hearing
what
when they pulled it.
Submitted.
No.
So I have a history here of what was approved by CCB, but what was disapproved by the commission was really more, I mean, this was a broad, for example, this product has undergone treatment using method of treatment. So, I mean, that's what CCB approved and what the commission didn't approve. So, I mean, where was it approved that that it should go in the soil amendment instead?
At the Ledge Commission. The legislators specifically told us, here's what it has to be.
Okay, I was looking at the minutes. It sounded like they were saying we don't actually have the authority to tell you where it should be, but we're telling you we don't like how it is currently. So I kind of, after the December, after the December 22, or sorry, the December 28 Legislative Commission meeting, I had trouble really finding like kind of what happened after that with it. So there were just other versions which were proposed to the commission, which.
Nothing, honestly, nothing happened after that. We were waiting. There's procedures in our regs on how to handle the regulation when it goes to the Ledge Commission, and we're still waiting.
Okay, got it. So, okay, got it. Okay, I can move on to just one final little thing. Okay, on packaging and labeling, I just wanted to make a general request on 12.030, 12.035, and all of those. And 12.015, just and I've talked with you about this, Kara, and I was supposed to get back to you, and I never did get back to you. So I think it would be really helpful if there could be language in each of those regulations which states, all of these elements are required to be on the packaging, but if they already appear on the label, or vice versa, if they already appear on the packaging, then they don't have to, they only need to appear one time. And I know a lot of the concern is labels fall off and things like that. And so, if something appears on the label but not the packaging, and then the label falls off, now the consumer doesn't know whatever was on the label. But
Let's start off real quick. The label never has to be attached to the package. The label can be completely separate. It can be emailed, text, code, anything.
I do agree with you, but we've had instances where we were approved to put information on. I think I'm conflating. We were approved, even though the reg said we had to have information put on one place, we were approved to put it on the other, provided that the label was permanently affixed.
Yeah.
Okay.
So that would be it. And it's a packaging requirement, but you got it on the.
Right. Okay. Yeah, because the label is permanently affixed. So I would request that perhaps there should be language, because it is a concern about the label either falling off or just flying away in the wind, that maybe we could say, you don't have to put all this stuff on the packaging if it appears on a label which is permanently affixed.
Okay.
And, if that means we're only allowed to use some like super adhesives, I don't know, whatever works for y'all, we're happy to comply. It's just like a spacing issue, we just like the flexibility to put things wherever they kind of work on the package, whether it's.
I know there's certain things they absolutely it's legislated to absolutely be on the package, but.
Yeah, but maybe like packaging could include a pre-approved permanently affixed label.
Yeah, and so
or
to your point, about the legislature requiring things to be on the package, in my view, I think there may be some debate on what does package mean, because I don't think label isn't specifically defined in the reg. So, when you put a label on a package, isn't it then part of the package? And so I think we can still be compliant with the statute, even if it's on the label instead of the colorful consumer facing package. If it's still permanently affixed, then now it's part of the packaging, is my take on it.
Yeah.
And so, the language relating to permanently affixed, and also language relating to, if it appears in one place, it doesn't need to be in the other.
Okay.
That's my suggestions.
Yeah, I'll draft something, and then when we get to the packaging and labeling workshop, take a look at it and see if you have any further comments. Yeah. Fair.
Anybody else on Reg 12? Anybody online for Reg 12?
There's no online comment.
Anybody here in Las Vegas for Regulation 13?
That was going to be an easy one.
Amanda Connor with Connor and Connor, Regulation 13. 13.010, similar to the comment that Lake made regarding reporting times before. This one requires reporting loss or theft immediately. However, 6.130, I believe, gives 24 hours for loss or theft. So I get that it's in a vehicle, but I would think you could probably still more from a facility itself. So if we can do 24 hours for that, maybe we can do 24 hours for the vehicle. That was my.
What was the other, the 6 point?
I think it's 6.130 subsection 1. I don't have my electronic version, so.
I don't have to scan everything later.
Give me 1 second.
We'll try to get them all consistent though and not conflicting.
Yeah, it's just a hard when some of them conflict, right?
Yeah.
Like that. 1, 3. There's a lot in 6. Sorry.
That's all right. I can find it from there.
Yeah. 6.130 subsection 1.
Perfect.
Great.
Thank you.
Thank you.
Anybody else on Reg 13? Online, Reg 13?
No online comment.
Anybody Reg 14? Online, Reg 14? All right.
No, there's no comment.
Anybody here in Las Vegas on Reg 15? I know we've only got one really close to opening, so. Anybody online for Reg 15?
No one online.
Abby can talk to us at the meeting, right? If we're meeting after anyways. All right, and that concludes our solicitation.
Public comment?
Yeah.
Yeah, solicitation input for agenda item number 3. Again, massively appreciate you guys' time and effort in coming here and helping us with this. I'm going to try pushing this out potentially every year, hopefully like every January, February, probably every January because session starts in February, but.
Is it public comment? I just wanted to ask.
Just a second. And we'll move on to public comment. Please keep your time to 3 minutes, and we're open to public comment here in Las Vegas.
Sorry. But for the record, Abby Kaufman, and this is really quick. It's not a formal prepared comment, but for the workshops that you all mentioned that are coming up, as much as you are able, if we could get like at least tentative dates as soon as possible, especially for the one in March on testing, since that was such a hot topic, and in even looking out like further, if we could have a tentative schedule for when these are going to be happening, so we can plan and so that the relevant people are available to be able to add their voices to the conversation. I think that would be really appreciated, but really appreciate just even with the fast turnaround, all of the conversation today, and look forward to a great 2024 with you all.
Thanks. And the regs will be up in more than a day and a half to 4 minutes.
Amanda Connor with the law firm of Connor & Connor for the record, and I apologize if I misunderstood Mr. Miles' comment before. I think he said that the special events regs would not be subject to the ATPPA.
Yes.
I was just trying to clarify that. My understanding is there was a petition for them made in July of 2022, heard at the July 2022 CCB board meeting where it was, the petition was denied. And then the next time, my understanding is they came forward was at a workshop in August 24th of 2023. I believe SB 328 says that the regulations proposed by the board after the effective date of the act of SB 328, which was June 14th, 2023, must be a part of the APA. So I just wanted to clarify that.
And these are being kicked around. Well, I'm not supposed to respond, but these are being kicked around for that entire time. So that's why they're still falling under. It's one of the last ones. There's only one more that potentially could be, and then that's it.
Yeah, I just, I wanted to clarify.
Oh, thanks. Anybody else have public comment? Any public comment online?
To provide public comment, click the raise hand icon at the bottom of your screen. There's no online comment.
Okay. I think I missed out on regulation 16, and I just wanted to.
There's no regulation 16.
Oh,
Oh, you're talking the event regs from or prior. Yeah, you,
I thought
3 minutes, good.
Okay, sure. So, and in particular to, I just lost the page. NCCR 16070, and it has to pertain with impaired driving. Just want to put a state for the record that pretty much according to Dr. Ethan Russo, acetylcholinesterase inhibition is what serves to reduce or eliminate like short-term memory or impairment by THC. In other words, it's within the alpha-pinene terpene or terpenoid. So I believe when the initial provisions were made, I believe back in NRS 453A and also amended in SB 374, those trials wasn't yet established. So now that we have some basically new data in terms of within the scientific communities, we should look into basically correlating all that experiments to the way we move on with our policies moving forward. So that's all I want to say. Thank you.
Thanks, appreciate it. Last chance. All right, let's move to adjournment. This meeting's adjourned. And again, thank you for all of your participation. Really appreciate it. If you have any additional comments, please feel free to throw them on the next couple of days on our regulation email.
Thanks, everyone. I feel like these were really helpful.
You guys just want to hang in here.